Committee members, we're going to get started. It's nice to see everyone today. So we'll start with committee member introductions, and I just want to give everyone a little bit of information about how we're going to proceed today. We're going to start with LD 2121, have the public hearing on that first, and then have the public hearing on LD 2059. And then from LD 2059, we'll move into some other discussion topics that we're having. And so with that little update, we're going to start with committee member introductions. Representative Sinclair, would you like to start us off?
Good afternoon and welcome. I am David Sinclair for the people of House District 50. That's the city of Bath.
Good afternoon, everyone. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Good afternoon, everyone. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Milton, Hanover, Roxbury, and my hometown of Rumford.
Hi there, I'm David Hagan, Senate District 10, 12 towns surrounding Bangor, but not Bangor.
Represent Babin?
Good afternoon. I'm Mark Babin. I represent House District 3, Northeast Aroostook County.
Good afternoon. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Hello, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Welcome. I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee.
And I'm Ann Carney. I serve Senate District 29. That includes South Portland, Cape Elizabeth, and some of Scarborough. And I serve as the Senate Chair of the committee. And just a moment. And so as I mentioned a moment ago, we are going to start our afternoon work with the public hearing on LD 2121. So we're going to open up the public hearing, and I'd invite the bill sponsor on LD 2121, an act to enhance the safety of judicial and elected officials, constitutional officers, and the state auditor by allowing certain personal information to be removed from designated public records. Welcome.
Representative Kuhn, members of the Judiciary Committee, it's an honor to be here. And first, I have my most important duties to attend to, which is the provision of what I consider the creme de la creme of candy, the Ferrero Rocher, to the committee. I don't know whether I should provide it to Soupy, of course. Yes. It's a great honor to be here as a returning member of the committee. And it's an honor as a former member, but I also haven't, my most important candy duty has not been executed, which is to provide to Soupy her own special Ferrero Rocher, because of all the people I've known over the years, many years in the legislature, she is one of the kindest, most hardworking people that I've known, and I feel like she has one that she's in control of if you bow down to her properly. I always bow down to Soupy because of what a wonderful person she is. And also, she saw the Beatles at Shea Stadium. So, round of applause for her. Members of the committee, I am Sean Faircloth, and I'm here to speak about LD 2121. I will say that when I served on this committee, it would never have crossed my mind to introduce this type of bill. But the world has in fact changed. Nearly 40 states have already passed laws similar to the bill that is before you today. And in collaboration with the Judicial Department, here is a vehicle for increased safety for those carrying out their civic duty. And I urge this committee to take this bill and then on your own craft this legislation to make home addresses of judges and elected officials less accessible via public records and data brokers. Now, why? The U.S. Marshal Service tallied 179 serious threats against judges in 2019, 224 in 2021, 457 in 2023, 509 in 2024, and 564 in 2025. In 2024, there were bomb threats on the homes of two of our main legislative colleagues. The Speaker faced a bomb threat on his home just recently. In a quarter of U.S. states, judges have been violently assaulted, in several cases killed in recent times. I submit a straightforward principle. Judges and legislators are public officials. Their official interactions occur in public. When a citizen interacts with a judge or a legislator, they discuss different types of issues, but there is nothing about either of these interactions that necessitates that they occur at the place where the judge's child lives or where a legislator's spouse lives. The homes of public officials are not the place for official interactions. Homes are where judges and legislators quite reasonably let their guard down. The legislation before you was inspired in part by Judge Esther Salas. See, there was a man who wanted to meet Judge Salas, so he got her home address on the internet. The man wanted to meet Judge Salas so that he could kill her. The killer was proud to call himself anti-feminist. The killer rang the judge's doorbell. Her son Daniel answered the door. Daniel tried to protect his parents, but was shot dead. His father, badly injured, survived. Daniel's parents spearheaded what became Daniel's Law, a New Jersey law and now a federal law that mirrors it, empowering people like judges and elected officials to request that the government keep their home address private and that data brokers not disclose their home address for profit. Some might call Texas, Florida, Georgia, Idaho red states. California, New Mexico, Washington State, Hawaii, New York might be called blue states. They all have laws providing that judges and legislators need not have their home address easily accessible online through a government website, and some prohibit or restrict online use by data brokers, a business which profits from your home address. Most know the name Melissa Hortman, Minnesota House Speaker, assassinated with her husband on June 14, 2025. Less known is State Senator John Hoffman, shot 9 times. He survived. And his wife, Yvette, who threw herself on her child to protect her child from being shot. She was shot 8 times and she survived. Also on June 14, 2025. The assassin got home addresses of the Speaker and State Senator from a data broker's website. There was a headline that said, quote, "Data brokers are a killer's best friend." Representative government should be a celebration of democracy, a joyful process. Yet according to a recent Brennan Center survey, 40% of state legislators said they were less interested in running for re-election or higher office because of hostile emails and hostile voicemails. For women, about half were subject to verbal or written assaults that discouraged them from public life. Being in elective office is an opportunity to serve, to help others. Maine needs a mechanism in place that encourages public service. Some options: Georgia is an opt-in state in the sense that legislators and judges must request that their home address be removed from public-facing websites. Washington State is more strict in excluding the addresses of elected officials and judges from public record requests. A New Jersey court found that Daniels Law was constitutional because it expressly limited its restrictions to discrete categories of current and former public officials because those are, quote, at particular risk. Home addresses are not the basis of a legitimate public interest. Here in Maine, our Capitol Police report threats against state lawmakers doubled from 23 in 2023 to 53 in 2024, then more than doubled again to 111 in 2025. Think about that number, 111 in 2025. We have 186 legislators. The Florida legislature passed a bipartisan law to stop data brokers from listing judges and legislators' home addresses. Ron DeSantis signed on to a proposal along these lines. Gavin Newsom signed a law permitting removal of personal information. Texas, Oregon, Vermont have opt-out laws applying to data brokers. Justin Sherman, an electronic privacy scholar, states data brokers and people search websites have enabled horrific violence by aggregating and selling data on people and their families. I began by discussing my love of this committee and the intellectual challenges and issues that you face in this committee. And the issue I place before you is not a particularly comfortable topic. It's an uncomfortable topic about increasing violence in our civic life. And this legislation offers you a doorway, a path to, in part, address it. Tackling tough issues is the greatest part of being in this room and the best education there is. I think of this committee with great fondness from my time here. You know, I really consider it one of the great experiences of education. I love going to college. I got to study abroad in Ireland. I even love law school. But this committee is where you really get educated about issues in great detail and of important and weighty effect. And no education ever matched the learning that I experienced here in this room, around this horseshoe, about the ideas and policies that you face. And from that vigorous learning and discussion, from that positive work, we find even judges, even legislators need to have a home to go to see family, to feel safe and recharge in a home that need not be a fortress, so that we may return to the people's business refreshed and ready to go. This has become increasingly ominous, this issue in recent years. And we need to look at that and then balance these issues. And I would submit that setting up a system, which I think could be simply done, this is my own suggestion, but simply done with a statute that makes clear that the registry of deeds information that's held by a government entity, that other information of the home addresses of judges and elected officials that are held by the government not be public because there's not a need for that to be public. And then secondly, as an additional part of this legislation, that data brokers be restricted because, as was stated in the case reviewing the Daniels Law, that these are particular classes of people who face significant endangerment in reality and are a distinct class and worthy of protection. So I hope you will consider this legislation and the models from other states that I've discussed. Thank you very much for hearing me out, and I'd be happy to answer any questions that you have.
Thank you very much, Representative Faircloth. Committee members, are there any questions for the sponsor? Representative Lee.
Thank you. You keep on referencing data brokers, and I'm trying to find, is there something specific in the language that deals with data brokers, or?
There is not. And to answer that question, we work with the Judicial Department. Initially, there were two bills, and it came down to one bill that was incorporated into under a bill under my name. So I would submit to you, though, speaking to you individually, Representative Lee, that my own opinion is that without addressing data brokers, the efficacy would be limited, that the governmental websites are an important important puzzle piece for this, but that currently in a lot of jurisdictions, the data broker situation sort of leaves the barn door open when it comes to public safety for people in this vulnerable and increasingly vulnerable situation.
A related follow-up.
Yes, you can ask a follow-up.
I ask about that because it does seem like how do you put the toothpaste back in the tube, right? My address is out all over across the internet. And so I don't see any mechanisms in this language that would deal with that.
Right. I think that, thank you for the question, Representative Lee. I think that if one were to take this legislation as this committee could and recraft it so, and this is my individual suggestion, is that you had strong directive language to data brokers that simply say, thou shalt remove the information regarding these categories of people. I think that would be the easiest to administer and be most effective. Others would have different viewpoints on that. But in my analysis and spending more and more time reading about this topic, which was first brought to me by the Judicial Department, and early on we talked about, the assessor's map that the government controls or the registry of deeds that the government controls, where oftentimes these addresses are readily accessible there with government entities, but that unless you have this additional part, it's going to be less effective. And I think there is not a strong argument, and as I discussed with the New Jersey case, for leaving these addresses out. I think that serves a public interest, and that a big public interest is not lost if I don't know Representative Lee's home address.
Yes, Representative Kuhn?
First of all, thank you for bringing forward this legislation. I agree with you. It's an important conversation for the legislature to be having at this time. I actually have two questions. The first, you stated that home addresses are not of public interest. And I can imagine a scenario where a member of the public wants to be sure that their representative actually lives in their district.
Yes.
Is there a mechanism to address that?
Yes, I believe some states have a system where it's kind of like a registry, and this would be for judges as well. Like you could have, for example, well, in Maine, like the probate judge, one of whom I'm familiar with, she has to say that she lived in Penobscot County when she's running for probate judge. Obviously, with once we're appointed, that wouldn't be the case. But you certify where your address is to the state, but that doesn't mean that that needs to be accessible to everyone on the internet, so long as there's a certification. Similarly for me, I represent a part of Bangor. I don't represent all of Bangor, but I think it would be fairly straightforward to create a system where there's a certification that says, yes, this person has demonstrated that they are a resident of the portion of Bangor in my case, and that would be acceptable and meet the need of ensuring that I'm not running from Wittapitlock.
That's one more question.
Yes, go ahead.
Thank you. So I've been following Daniel's Law for a couple of years as it's moved around, thinking about the implementation. And what a number of states have done, including Minnesota, following the events there, is instead of creating a process within the state to do this kind of verification, they outsource it. They direct the state to enter into a contract with, for example, Delete Me or some other platform that's in the business of doing this and limiting data that's available to data brokers. And I just wondered if you, in sort of thinking about the implementation and taking it in-house versus sending it out, did you look at that as a possibility?
Yes, in my reading about it, I did look at that, and I think that's a viable option that has been considered, as you have pointed out. I also would just lay it out for consideration by the committee that if there was something directive that said to a data broker, you'll remove these categories and we want you to scrub out these categories, that might also be a cost-efficient way to achieve the goal.
Thank you.
Representative Sinclair, did you have your hand up?
I half had my hand up, Madam Chair, for about 13 seconds, but Representative Kuhn asked the chief question that I was contemplating. I'm happy to throw forward another one, though. I was going to note that you've got a section, a definition for covered persons, but not for expressly covered documents or record types. And instead, you refer on line 22 on page 2 just to certain records. Did either you individually or you in discussions with the judicial branch identify either certain classes of document that you felt sure ought to be included or certain ones other than the listed exceptions that you felt ought to be outside that protection?
Well, in deference, that was primarily a draft from the judicial department. And are you asking like the types of documents that the government controls? In our conversations, we talked about the registry of deeds and the assessor's office where you can go and find it rapidly, someone's home address. But I think it was the intent in conjunction with the judicial department to expunge any information that relates to those two categories of people and to list those out. And maybe those two examples I have given are not comprehensive, but I'd suggest that it's worthwhile to amend the bill to make sure it has a comprehensive list.
You may ask a follow-up and then Representative Pugh, you're next.
Thank you for that answer. And so understanding that the intent was that all documents not expressly accepted would be included, what was the mechanism that was envisioned for breaches, for failure to redact? What, if anything, is the recourse for that individual whose address continued to be published in contravention?
And you're talking about
A covered
governmental, but I mean, so are you talking about if their address is still listed with the registry of deeds or the assessor's office when there's been a directive by law not to have a judge's
still
address
listed anywhere where it oughtn't to be?
As far as a kind of recourse or sanction for it? No, I haven't. I was hoping that if a governmental entity received that instruction, they would follow through on that instruction. So you're saying if the government, like a local government, decided they were not going to adhere to that?
Thank you. Are you all set?
He asked me a question. I'm happy to respond or not.
Go ahead and respond.
I don't know that I meant necessarily that a local government would intentionally not. I was asking whether there was anything available in terms of redress in the event that they either negligently or simply through delay failed to act in a timely fashion.
Right. As far as delay, I think some of the other states set a time period and say you'll remove by X period of time. When new people are elected or new judges are appointed, I think that's how they set that up. I admit I hadn't thought about if they simply neglect to do it and what the sanction would be. So I don't have an answer, but it's a worthy point to raise.
Representative Pugh?
Thank you, Madam Chair, and thank you, Representative, for this important piece of legislation. My reading of this as it's currently drafted is that it would be an opt-in process so that your address and other information would by default be publicly available. I guess, is that a deliberate choice, and could you explain the motivation for that if so?
Well, thank you, Representative Pugh, for that question. I worked on this in collaboration with the Judicial Department, who will follow me. And certainly the option method is one that's used in a lot of different states. However, I will confess to you that I would individually submit, having spent a lot more time reading about this, that it might be cleaner, easier, easier to administer, potentially, if you simply said, this shall not occur, rather than have an opt-in or opt-out. I might, as a legislator, or someone might, as a judge, say, oh, I don't feel that worried, or I'm not that concerned, and I'm going to individually apply or not. But I think as far as looking at the public interest broadly, it might be cleaner and frankly more practical to simply say this category will not be listed. And as I mentioned from the case in the review of Daniel's law, that at least in that instance, the court found that's appropriate, that's reasonable, because this is a class of people who face an elevated level of risk. And then you don't need to one by one the process. You set forth in a way that's by category in full.
Additional questions, committee members? Representative Henderson?
Thank you, Madam Chair, and good afternoon, Representative Faircloth. I didn't know that you served on this committee, so thank you for tribute. So I'm sitting here kind of arguing internally with myself on the reasons why I like the bill and the reasons why I don't like the bill. And maybe to help me kind of get to a place where you are, my internal argument is, and I promise that this has a question, I'm just trying to get there. My internal argument is that we are representatives of the people for the people. And Representative Kuhn really kind of honed in on my main concern of just your average everyday citizen wants to know the person representing them actually lives inside the district. And I appreciate your response. It doesn't quite satisfy me, my answer, the certification process. But you had also made a statement that there just isn't an argument good enough to outweigh the risks at hand. Can you help me maybe a little bit grapple with your average everyday citizen who wants to ensure, or maybe an investigative journalist who wants to ensure that the person is living there? How do we instill trust in the system, trust in government, when you go to see where your representative lives and it says they've been certified to live in the district and that's all you get?
Right. Well, first, thank you, Representative Henderson. And I do recognize that that is distinct from the category of judges, except for possibly ones who are elected like probate judges. And I understand that there's an issue there. You know, we all have run for office and we've all put ourselves out there as the folks on the street who go meet our neighbors and represent them. So I understand the ethic that you're laying out, and it makes sense to me. However, as I look at one dramatic rise in the numbers that I specified in my initial testimony of threats against people's lives, in some cases, I think there's a very significant issue at play here that makes it more difficult for people to be that legislator on the street that is accessible, and that you can be very accessible. First of all, by being accessible, if you choose, you can invite someone, or I could invite someone to my home, or meet people out in the community. So the only distinction here I see as far as the perception of the average citizen is that they maybe come to a point where they say, how do I know this person is my state representative who lives in my district? And that this certification process that I suggest, I think is a practical, reasonable method so that you can say, yes, we're having some objective third party certify, which would be fairly straightforward, that this person in fact does live in the district, and that any loss of confidence from that would be fairly de minimis compared to the kind of risk that we are increasingly seeing. The bomb threats I mentioned are real. The increase in the number of threats to people in this body, doubling for a couple of years in a row, shows there is a very significant public policy issue at play here. Whereas I think if any of us on the Judiciary Committee, as you as members or me as legislators anywhere, want to go out and say hello to our community, we're putting ourselves out there. We're going to do that. We just don't necessarily have to have the specific address where my children are, my spouse is, listed publicly, especially when there's so many threats going around. And I think that inhibits potentially the service of legislators. The statistic I gave about threats to legislators and deterring them from running for higher office, and the apparently increased number and percentage of threats to women elected officials. So to me, on the balancing of the scales, I think it's a reasonable way to address the issue.
Thank you.
Representative Caruso and Poirier, would you like to introduce yourselves?
Good afternoon. I'm Elizabeth Caruso. I represent the people of House District 72, which is much of northern Somerset County.
Hello, I'm Jennifer Poirier. I represent House District 70, which is Skowhegan.
Can I ask if there are any final questions, but also I would like to know, Representative, if you're going to be able to join us for the work session on this bill.
You bet.
Okay, great. Then we'll probably have more questions for you at that time. Representative Sinclair?
Thank you, Madam Chair. I appreciate your well-reasoned responses to Representatives Henderson and Representative Kuhn with respect to the issue of making sure that a member of the public can ascertain that the person running to represent them actually lives in their district. I would point out that line 12 on page 4 specifically accepts the nominating petitions from the necessary redaction. So that information, if I'm reading correctly, would always be available in any event.
I won't.
Yes, Representative Caruso?
Will you be making your testimony available on paper, or did I just not get?
I didn't provide it and I'm happy to provide it.
Okay.
Yeah, although it has scribbles on it now, but yes.
If you could file it electronically, actually, then it's available, easily accessible to the public as well
Yep.
as to all of us. I'm not seeing any more questions. Thank you very much
Thank you.
for presenting this bill. Committee members, we're next going to hear from Senator Donna Bailey, who is the lead co-sponsor on this legislation.
Thank you. I too am a former member of this committee, so this is your lucky day. So when I was trying to think of what I should bring for a tribute, I was thinking about the long days and hours you all put in. And so I wanted to try to get something that would perhaps last more than one meeting. And so I'm hoping that this will maybe last, I don't know, maybe 2 or 3 meetings.
Beautiful. Thank you. Thank you, Senator Bailey. And
True
Senator Bailey.
confession, my husband likes to shop at Costco, so.
And Senator Bailey is not only a former member, but a former chair of this committee.
Right.
Thank you for joining us today.
Thank you. And Soupy, whenever you're ready, I do have testimony to pass out. So good afternoon, Senator Carney, Representative Kuhn, and esteemed members of the Judiciary Committee. I am Senator Donna Bailey, and I represent Senate District 31, which consists of the towns of Buxton, Old Orchard Beach, and Saco. Today, I'm pleased to offer testimony in support of Representative Faircloth's Bill LD 2121, an act to enhance the safety of judicial and elected officials, constitutional officers, and the state auditor by allowing certain personal information to be removed from designated public records. For those of you who may not know, I have a long career in public service spanning over 39 years. At different points, I've been an attorney, a guardian ad litem, a probate court judge, a state representative, and currently a state senator. All that is to say, I am familiar with the increased attention, wanted or not, that public officials and those who make difficult decisions that affect people's lives often receive from the public. That being said, in January of 2024, for the first time ever, I and other colleagues received a serious threat via email. This is the first time I've spoken publicly about this incident, but I believe it is important the committee understand why the bill before you is needed. The subject line of the email received read, "You're going to die." And the body text of the email read, "I'm going to kill you and all of your child raping friends." Aside from the disturbing content of the email itself, just as unsettling was the anonymity of the sender. Indeed, when I received that email, I did not know the sender, where they lived, or who they were. And I did not know what they did or did not know about me. This situation left me feeling like I always had to look over my shoulder wherever I went, home, the state house, and everywhere in between. Now that the case is closed, I'll share with the committee that as a result of this threat to kill me and others, this individual is currently serving time in a federal prison. Some people might be thinking, well, it was one email from one person who is currently behind bars. I wish it were so simple. We are living through an historic moment of heightened political violence, as you just heard about from Representative Faircloth. It affects public officials at all levels of government in every state. And sure enough, just months after receiving the death threat outlined above, I experienced another first in my own career. I received a bomb threat to my home. Again, my sense of comfort and security was disrupted on a quiet Saturday morning when the chief of police and the deputy chief of police knocked on my door and requested permission to sweep for explosives at my home after having received credible information of a bomb threat to my residence. Shortly thereafter, I received another bomb threat to my home, and I had another visit from the local police to sweep my home for explosives. Following these incidents, I had to install a video security system at my home where I was concerned not only for my own safety, but also for the safety of my family, my friends, my neighbors, and my pet. Let me be clear, it gives me no joy or satisfaction to describe these experiences to you all. As you can tell, it's actually quite difficult. I wish that we still lived in a world in which an email, a letter, or a social media post did not convey the intent to cause serious harm, including death, to public officials. But unfortunately, we do not. We need to add a layer of protection to public officials like you, like me, who are increasingly at risk. Thank you for your attention, and I'd be happy to answer any questions you may have.
Senator Bailey, a heartfelt thanks for sharing your experiences with all of us. Committee members, are there any questions for Senator Bailey?
Thank you.
Thank you
And I
very
do
much.
have to get back to my committee, so.
We very much appreciate your time today. Would the next person who wishes to speak in support of this legislation, please step forward. Welcome.
Good afternoon, Senator Carney, Representative Kuhn, members of the Joint Standing Committee on Judiciary. This afternoon, I am standing in for Chief Justice Valerie Stanfill of the Maine Supreme Judicial Court. On behalf of the judicial branch, I am asking you to support LD 2121 to help protect our judges and our elected officials. So to be clear, these are her words and not mine. In 2024, the American Bar Association reported that serious threats against judges have doubled since 2019, with 457 serious threats targeting federal judges across the country in 2023 alone. And keep in mind that federal judges are but a small percentage of judges in this country. And it is not just threats. Judges are being attacked and killed for doing their jobs. Some are attacks at courthouses. In 2024, a Kentucky judge was shot and killed in his chambers, but some occur outside courthouses at judges' homes. As I prepared this testimony, I wrote that most recently, in 2025, a Maryland judge was shot dead in his driveway. However, that is already out of date. I awoke this morning to news that an Indiana trial judge and his wife were shot at their home just over this past weekend. In Maine, in recent years, there have been a dozen or more serious threats against our judges annually. In 2025, one of Maine's judges spent 2 weeks in a hotel with the judge's spouse and children because of threats against the judge and the public internet, and the fact that the public internet listed the judge's home address. This danger is here in Maine as well as elsewhere. We understand that this legislation will not guarantee anyone's safety or the safety of any given judge or elected official, but it is an important step to protect the security of those who serve the citizens of Maine. Thank you very much for your time.
Thank you very much for reading the Chief Justice's testimony, and I will ask committee members to defer questions, and we can ask them of the Chief Justice at a different time if you have them.
Yes.
Julie, thank you very much.
Thank you.
Would the next person who wishes to speak in support of this legislation, please step forward. And before you start, Barbara Cardone, could you just hold one moment while we set up the timer? I'm sorry? Could you just wait one moment while we get the timer up and running? You may begin. It's going to take a little while for the timer to wake up. Go ahead.
As Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on the Judiciary. I'm Barbara Cardone, Director of Legal Affairs and Public Relations for the Maine Judicial Branch. I'm testifying here in favor of LD 2121. I'm not going to repeat this policy reasons and the statistics that you've already heard. I want to direct my testimony on the structure of the bill, the drafting of the bill, and on the work, the revisions that it's going to need. First, I can assure you that this bill as printed needs to be revised. And I know that because I was the primary drafter of the bill. And by the way, I'll be happy to answer any questions you have about drafting. The initial draft was put together to meet the cloture deadline and without the opportunity to work the text with the various stakeholders. We are in the process of arranging a meeting with your committee analysts to work on revisions. We plan to bring a revised draft to the work session. Second, I wanted to let you know that 38 states have some form of a statute dealing with keeping personal judicial information out of public circulation. No two bills are alike. We don't have a model law on this subject. There is no single template to work from. Some of the states have included elected officials, federal and state, and some have even included police officers, healthcare workers, and social workers. Although there's no basic model to work from, most of the statutes contain provisions that answer 5 basic questions. And this is the important part, most important part of my testimony. These 5 questions: who is covered by the statute? What state and local governments or agencies are tasked with keeping information private? What information may not be shared by a state or local agency? Who notifies the state or local agency who possesses the public record that they may no longer release the personal information? And does the law prohibit posting or publication by third parties, i.e. data brokers, or somebody who's ticked off and decides to go onto Facebook and post a judge's information or a legislator's information that they have? I think that keeping these questions in mind when you review and analyze the draft text will help each of you to frame your thoughts about the bill and will help guide you in a committee discussion about what should be in the bill and whether the draft you are considering is complete. I would be happy to take any questions you have.
Thank you very much for your comments. Committee members, are there questions? Representative Henderson?
Thank you, Madam Chair, and good afternoon. You mentioned that you're going to be working on a draft and that you're going to be presenting it at the work session. I presume that that's working in conjunction with the bill sponsor?
Yes, what I am hoping to do is we're shooting for Friday, but I'm not sure. I also want to work in conjunction with your analyst. Janet Stocco was assigned this bill, and I thought it would be prudent to work with her from the beginning on this. But it'll be the bill sponsors, it'll be me, it'll be the Secretary of State's office, and anybody else who is in the room who would like to have input on the bill. This is something that I wish we had been able to do before we even did the first draft of this bill. Unfortunately, the timing was bad. We had to get it in before cloture. Haven't had a chance to talk with all these folks. And frankly, I'm afraid that if we don't do this and if we don't try to work through some of these issues before you go into work session, the work session is going to be a mess. There's just going to be too many options and too many things to look at and too many questions to ask. Going through 38 or 40 statutes, all different, it may not be particularly helpful. It's certainly not going to be particularly efficient. So we're trying to work on the efficiency as well as the helpfulness of the draft.
Thank you. May I ask a follow-up?
Yes.
And thank you for that. I know that you can't speak directly to Chief Stanfield's testimony, but it seems as though between the two testimonies given from the judicial branch as a whole has been more focused on the judges portion of this rather than the elected legislators. Has there been discussion within the judicial branch on that? And are you able to give an official statement or perspective?
Oh, absolutely, absolutely. Yes, and I can speak to the Chief Justice's testimony. Yes, we are focusing our testimony on the judges, but in my discussions with Representative Faircloth back when we were thinking about drafting this bill, I knew that the legislators were concerned and that there had been talk in the legislature about drafting a similar type of bill to protect legislators and other elected officials. So yes, we partnered from the beginning. What we're providing you is the judicial perspective, but absolutely, we want it to encourage include legislators and any other elected officials that this committee thinks are appropriate.
Thank you.
Senator Hagan?
Thank you very much. I'm going to throw the slowest softball in the world at you. If there's a chance that you guys are done with all the revising and all of that for the amended version, could we get it before the work session? Like, I'd love to go over it at night, just kind of, take it all in.
I am working with your analyst, and I would, that's my hope anyway, and I would think that she'd be able to, if your chair so wish, she'd be able to distribute it to you before the work session. I or the judicial branch would have no problem with that.
Yeah, and we are very mindful of the need for people to see it ahead of time.
Yeah, this is a complicated subject.
Yeah. Representative Caruso, and then Lee, and then Poirier.
Thank you, Madam Chair. Thank you for your testimony. I agree. Love to see it beforehand so I could delve into it. You mentioned here that some other states have included other individuals, and you mentioned some law enforcement, and I know that there's a lot of threats to our law enforcement right now that I don't feel they're safe. And I was wondering if you had included that in your discussions when there was a drafting of the bill. I didn't ask the bill sponsor. Was that discussed as well?
Yes and no. As I just admitted to everybody, I was in a hurry to get something in by the cloture deadline to save this bill. So I went to the New Jersey statute. I went to the Daniels Law statute, and I cobbled together something, changed New Jersey to Maine, changed some things, added legislators. The New Jersey statute doesn't speak legislators, but I did it very quickly, knowing it would have to be rewritten. So by the time I got it to Representative Faircloth, I had already put the legislators in. We have talked about what the scope of the bill should be, and that's question number one. Who is covered by the statute? I almost put this in my testimony and I didn't, but it seems appropriate to mention it here. There's one cautionary tale about this, because I've been in touch with the National Center for State Courts as well, and they're following all of these bills and statutes as pertains to judges. I spoke with the senior analyst who was doing the following, and he mentioned a cautionary tale that Maryland, I'm pretty sure he said it was Maryland, dealt with, in that they decided to bring a bill like this into a short session, and everybody started chiming in. Oh, we want in, we want in, we want in. And what happened is the bill got so complicated and so bogged down, he called it a Christmas tree bill. Everybody was hanging things on it. It got so complicated and so bogged down that it didn't pass. It just didn't pass in time. And I am concerned about that here. So to balance or to think about who is covered when you're thinking about this as a committee, I would keep in mind that you don't have to include everybody all at once. If it seems like it's getting too complicated, I think the important thing is to pass out a bill. And if that bill becomes law and then you decide in the next session, gee, we should add DHHS caseworkers or police officers or whomever, you can amend it to add it on. Better to bite off what we can chew, I think, than to try to get so global that it gets too complicated to pass it all. That's my only cautionary tale on that.
Thank you. Madam Chair, could I ask for the work session that we could see some language of the states that include law enforcement protections as well?
We will try to get that to you, but if you have a way of getting it as well, that would be helpful, but we'll definitely try to get it for you.
I think I may have a way of getting at least a list of the states that may include law enforcement. I won't promise it's exhaustive.
If you could provide that to Janet,
I will.
that would be very helpful. Thank you. Representative Lee, I think you're.
Upon reflection, I think it's more appropriate for the work session.
Okay, Representative Porter.
Thank you, Madam Chair, and thank. Sorry, thank you.
Barbara Cardone, yours also is off.
We all went out.
Is off. Okay, so
In my mind, I'm thinking practically how this would work. I'm thinking about, some things on the internet, it's there forever. You're going to be able to find it somewhere. I think of property tax records, deeds, things like that you can access online. And I think about, websites like Ballotopedia that has our information and oftentimes has our address and such that are out there from different states. So how do you envision this being enforced?
That's a good question. And one of the things that is in the draft, I think that I have, is we have to designate the office that is going to maintain and enforce this and give them some rulemaking properties. This bill is not going to cover every last option or every last detail of how this is going to be administered. And it's going to be difficult to administer. It's going to take, there's going to be a fiscal note on this bill. But those are things that I think are going to have to be worked out by the office that's put together. I think in the bill that you have, I talked about putting it in the Secretary of State's office. That may or may not be a good idea. That's one of the reasons that the Secretary of State's here. It may be creating a separate administrative office to do it. But I think exactly how they're going to have to enforce it and check up on it is something that they're going to have to, that's going to have to be worked out on a different level. I think the questions that's appropriate though for this committee is what happens if it doesn't get enforced, if it's intentionally thwarted. Are there penalties? Are there some states make it a criminal act if somebody goes and takes a judge's private information and posts it on Facebook? Should that be a crime? I mean, these are all the sorts of things that need to be thought about.
Yes, go ahead.
Thank you. So in the case that if it's like a business or entity outside of the state of Maine, would we be able to even enforce something like that?
Criminally, probably not. I don't know. I honestly don't know all the potential enforcement mechanisms. There are members of your committee who may have a better grasp on that than I would. But and the one thing I want to say, and I've said this to our judges too, this bill, in any way, shape, or form that we put it together, is not going to be a guarantee of anyone's safety. Not judges, not legislators, not anybody else that's covered. It's one step toward preventing information from falling into the wrong hands. But it doesn't mean you shouldn't use data scrubbers. It doesn't mean you shouldn't be vigilant. It doesn't mean that you should maybe not use social media in the way that you're using it. It's not going to be foolproof. And I wouldn't want to give anybody who's covered under this statute a false, if we pass it, a false sense of security. Vigilance is going to be the key.
Thank you.
Will you be with us for the work session?
Absolutely.
Thank you. Are there any other questions?
You
committee
could give
members?
us a little time for that though, so we can work with your analysts and get something drafted.
Yes, your request was heard, and yes, you may
Thank
have some
you.
time to work on it. Any other questions, committee members? Seeing none, thank you. Secretary of State Bellows, would you like to address the committee? Thank you.
Thank you. And I have testified before you every year since I've been secretary, but I am a former member, and Soupy does remind me that I do owe you a tribute. So here's my IOU. Senator Carney, Representative Kuhn, members of the Joint Standing Committee on Judiciary. My name is Shenna Bellows. I'm Secretary of State, and I'm speaking today in support of LD 2021. It is a sad truth about today's political and social environment that public servants are facing threats of violence and actual violence, as in yesterday, on a routine basis. Many of you have experienced this personally, like I have, or you know colleagues who have. And the mental, financial, personal toll that this can take on an elected official or judicial officer can be incredibly burdensome for that person as well as their family and friends. I'm sure we all know people who've declined to run for office or for reelection or even get involved at all because of the environment that we're in, and our communities are worse off for that. And I would say after we had completed my testimony yesterday, I was doxxed. Again, it wasn't the first time. My address and cell phone number were published with unfounded lies about me online in multiple sites. And I received more than 24 calls yesterday, over a dozen voicemails of various degrees of ugly and threatening. So I'm well supported as your Secretary of State. Law enforcement is wonderful. But the fact that this happened literally yesterday speaks to the necessity of the bill. So that is why I'm speaking today in support of LD 2121. The Department of Secretary of State has deep experience in managing public records with care as to what information should be public and what information should be redacted or confidential. We have a strong track record. We work closely with the municipalities and the counties regarding record keeping and decision-making around records. So we are well suited to house a new Office of Information Privacy to carry out the duties that would be assigned to the department under this bill. There are a few different models for public servant information privacy that we recommend that you consider and direct stakeholders as we work on an amendment to this bill. One version that seems to work well is the model that New Jersey implemented. I will note it covers judicial offices, prosecutors, law enforcement officers, child protective workers, and their immediate families in the same household. It does not cover legislators, for what it's worth. In this model, the State Office of Information Privacy trains designated redactors at the state, county, and municipal level and notifies them of their responsibilities. When covered persons apply through an online portal, that office then notifies the relevant entities that reductions must be made and that must be completed within 30 days. Once they're complete, the entity sends back to the state the list of redactions made. And so then the Office of Information Privacy communicates that to the covered person. Additionally, the law has been amended in recent years to cover the data brokers and other non-governmental entities who have 10 days to do redactions and notify the state of redactions. It works because it's well-resourced, and the Honorable Barbara Cardone spoke to this, but in New Jersey, the Office of Information Privacy is staffed with sufficient staff, as well as an online portal that is managed, and there's an ongoing appropriation. I'll conclude here. There's more in my written testimony. I'm happy to take questions, and I and or members of my staff will be available for the work session. Thank you for your attention.
Thank you very much. Are there questions for the Secretary of State, Representative Lee?
In the event that one of the third party or data brokers doesn't redact within those 10 days in New Jersey, what happens?
We'll bring that information back to
Thanks.
you for the work session. I think that the questions about enforcement are worthwhile. Through the Bureau of Motor Vehicles and the Division of Corporations, of course, we have some experience with civil enforcement and fines and penalties associated with noncompliance. We also run a hearings division, however, that allows people their due process option for an administrative hearing to appeal that finding. So it is not simple. It's easy. We can implement it, but it does require some resources.
Additional questions, committee members? Not seeing any, but I had a question for you because I'm not sure all committee members are aware of it. But the Secretary of State's office currently has an address confidentiality program. And could you just give us a little bit of information about that? Because it is similar to the issue we're discussing today.
Yes, of course. So we administer the address confidentiality program. We did explore this with the judicial branch and with a sponsor and determined it's probably not quite the right model for legislators and judicial officers. But let me explain it to you because it's incredibly important. It's under the jurisdiction of this committee. It's a program which provides a designated address. That's the Office of Secretary of State address to survivors of specific circumstances, including domestic violence, sexual assault, and stalking. It was recently expanded to include providers who provide access to abortion or gender transition services. So when one of those covered individuals moves to a new location that is unknown to the public or to their abuser or someone who has threatened them, this service provides a free first-class confidential mail forwarding service. So all of their mail comes to the Office of Secretary of State, and my staff then distributes it out to that person at their confidential address. We also redact their address from all databases that are usually used to access addresses. That includes the voter file. I will just say that if there's an exception in the voter file to address, you really don't have any privacy at all because that's so widely accessible. Similarly, we redact addresses in the driver license information databases as well as the vehicle registration databases. So the address of that covered person is masked in those information repositories held by the Secretary of State that are so frequently utilized by the public to access address information. So successful enrollment is specific to each survivor. I say survivor because traditionally it was domestic abuse survivors and sexual assault survivors, but it's usually we work with them one-on-one to walk through what are the potential threats to their safety. And the program does depend on partnerships with trained advocates. So we train advocates in nonprofit organizations to work specifically with the covered persons to walk them through the process. So it's very time intensive because it's very specific to an individual's situation. And because we're literally receiving their mail and then getting it out to them, it does create additional delays in the the delivery of mail that people take as a cost of the program, but might be particularly difficult for judges or legislators.
Thank you for that additional information. Representative Kuhn?
Thank you. You didn't get to finish your testimony, but I noticed that you do identify as an option the possibility of, instead of taking this work in-house in the Secretary of State's office, contracting out with an entity that does this for their work. And I just wanted to ask you, which a number of states have done. And I'm just wondering, do you see any advantage or disadvantage with pursuing that model as opposed to the way it's been proposed in state government?
That model is offered, just as you alluded to earlier, there is a model of offering paid subscriptions to a personal data removal service that's through the private sector, like Delete Me. And some states have adopted this as part of a safe at home program. So for example, in the first couple of weeks of offering this service in Kentucky last year, the Secretary of State for Kentucky reported they immediately had 15 participants sign up. 800 listings and 4,500 pieces of personally identifiable information were removed. So this would be an ongoing appropriation. It's going to be an ongoing appropriation regardless, because you're either going to need a pretty robust office to manage both people coming into the program to vet them and work with them, and then also the redactions themselves. But this is an alternative model, which is covering the cost of subscriptions, perhaps for judges and current legislators. You could think through what the cost of that would be. You'd still want some sort of state agency to be the, to have that contract. You could have it through, the courts and the legislature could each have their own small contract, or you could, as in Kentucky, designate the Office of Secretary of State to manage the contract. So yes, that's the pro to that is those private entities have experience in doing that. The con is when it's a public model, there's perhaps more direct accountability to the legislature, but there's the accountability of ending a contract if it's not successful.
Additional questions, committee members? Representative Henderson?
Thank you, Madam Chair, and thank you, Madam Secretary, for being here today and for reminding us that you do owe us tribute, not to be greedy.
Do you have a special request? Because maybe that's the spin I should put on it. I wanted to hear what you wanted before I brought it to you.
Sure.
Chocolate, non-chocolate?
No, I tell you what, whatever you bring, we'll be happy with.
Perfect.
So
Savory treats. Okay.
something
Note
to
to
balance
self.
it out a little bit. So I'm struggling a little bit with your testimony. This is an issue that I'm internally grappling with, but also really questioning the legitimacy of the testimony, given your recent announcement to no longer provide undercover license plates to federal law enforcement officers. So I guess my question is, can you reconcile for me why federal law enforcement officers shouldn't be granted the same protections as local legislators and judges?
So actually, the question is grounded in misinformation, and I would say from the original purveyors of the lie, an actual lie. So just to explain, there are two types of plates that federal agencies or law enforcement agencies can get. One type of plate states that it's law enforcement. So when you see state police on the highway, hopefully none of you are getting stopped. They've got the state police license plate. County sheriffs have the county sheriff license plate. State offices have a Maine state government license plate. Federal agencies have a U.S. government license plate. That's one type of plate that is available to any and all law enforcement agencies. The second type of plate is specifically under Maine law, unmarked plates, and they're for undercover operations. So we can all agree that there are legitimate undercover operations where an officer is putting their life on the line to keep us safe by infiltrating a drug trafficking ring or human trafficking operation. So our office routinely works with agencies across local, state, and federal government to provide those unmarked plates. Last week, we received a request from U.S. Customs and Border Protection for unmarked plates. And given what's happening in Minnesota, given the rumors of an ICE deployment to Maine, we made the decision that we are pausing the issuance of the unmarked plates, which present as civilian plates. Used to be the Chickadee, now it's the Pine Tree plate. And they're not traceable to anyone. Now, that it's important to note that the plates for an agency are not marked back to a member of law enforcement. So by not issuing additional unmarked plates, it's not that any member of ICE or member of law enforcement's personal information will be revealed. It's simply that they must then use an agency plate that is marked as U.S. government or as law enforcement in accordance with their agency that is linked back to the office for that agency. So the lie is that we are doxing or revealing the identity of law enforcement in any way. Of course, we're not doing that. We take individual privacy and security very seriously. And given my personal experiences, I am exceedingly grateful to local and state law enforcement for everything they've done to keep me safe, given what I've experienced. So I would never do that. And unfortunately, The reason I was doxxed, I believe, was because of a video that suggested that we were publishing individual information of law enforcement officers or ICE officers online. And it's simply not how it works. It's not information that we keep or have, and we would never do that. Thank you.
Any additional questions, committee members? Yes, Representative Lee?
For the work session, I'd be interested in the model that Representative Kuhn was asking about, how that's enforced, because my thought is you'd still need the government agency to do the enforcement.
We can investigate with Kentucky and a couple of the other states that have adopted that model just to see what the appropriations are and what the enforcement mechanisms are. And we'll circle back with New Jersey to verify their enforcement mechanism as well.
Thank you. Any additional questions, committee members? Thank you so much for being with us today and for all the information you're sharing.
Thank you very much.
Is there anyone else present in the committee room who wishes to speak in support of this legislation? That's LD 2121. Please step forward. Pardon me? Just go ahead. We're looking forward to hearing from you.
Good afternoon, Senator Carney, Representative Kuhn, and honorable members of the Joint Standing Committee on Judiciary. Excuse me. My name is Lily James, and I serve as advocacy coordinator of the Maine Women's Lobby. And I join you today on behalf of the Maine Women's Lobby. We are here today in support of LD 2121, and we thank Representative Faircloth for sponsoring this important bill. As you've already heard,
Excuse me, I accidentally turned off your microphone. Representative Babin is, yes, and we'll restart the clock.
No.
My apologies.
No problem at all. Thank you. In recent years, we have seen a growing trend of acts of politically motivated violence, as we've already heard about today. I won't go through, but there's other incidents listed in my written testimony. But as you've already heard, according to recent studies, the number of politically motivated plots and acts of violence in the past 5 years is more than 3 times higher than those of the last 25 years combined. The incidents laid out in my testimony are only some of the examples of the increased danger public servants and political figures are facing in the current climate. And we must not forget that political violence has for decades disproportionately been enacted against women, LGBTQ people, immigrants, and people of color. In Maine, as you've heard, we are seeing a severe and frightening increase of violence and threats, many involving public officials' homes. A few examples just from the past 2 years include a high-profile elected official who received numerous swatting attempts at her home, bomb threats that were delivered to the homes of committee chairs, and a member of leadership receiving misogynistic and racist flyers spread in her neighborhood. It must be noted that all of these cases, the targets were women, and the data of women elected officials, the data is, in general, that women elected officials experience higher rates of harassment and threats of violence. Allowing public officials and their family members to request that certain personal information, such as home addresses, be removed from public records and publicly available online resources is not a one-size-fits-all complete solution, but it does allow us to reduce their vulnerability to political violence by making it harder for perpetrators to locate, harass, and target them. Political violence is never acceptable. It is a threat to the fabric of civil society, and every person deserves to live in a world where they do not fear bodily harm or death because of who they are or what they believe, and certainly if they are providing service as a public servant. We hope you will vote ought to pass on LD 2121.
Thank you for your testimony. Committee members, are there questions? Seeing none, thank you. Is there anyone else present in the committee room who wishes to speak in support of LD 2121? If you are participating online and you wish to speak in support of LD 2121, please raise your electronic hand and keep it raised until you've been brought on to the panel. There are none. And is there anyone in the committee room who wishes to speak in opposition? If so, please step forward. If you are online and you wish to speak in opposition to LD 2121, oh, that's okay. Thank you.
Good afternoon, Senator Carney, Representative Kuhn, members of the Judiciary Committee. My name is Rebecca Lambert, and I'm providing testimony in opposition to LD 2121 on behalf of the Maine Municipal Association's Legislative Policy Committee. Our LPC is comprised of municipal officials from across Maine elected by their peers to represent member communities. MMA is a nonpartisan, nonprofit member service organization that aims to help provide policy solutions that work for all residents of Maine. It is the LPC's belief that public records exist for a reason. They are the cornerstone of transparency, accountability, and public trust. When individuals choose to serve in positions of public authority, they accept a higher level of scrutiny because their decisions affect the public's safety, finances, and rights. Limiting access to information about those officials, especially when it's already lawfully public, is a step towards eroding that trust. This bill would impose significant and ongoing administrative burdens on municipalities. Local governments would be responsible for reviewing and redacting information, responding to opt-in or opt-out requests from the newly created office, updating databases, training staff, and ensuring continued compliance. These tasks would require substantial time, legal oversight, and technical resources, costs that many municipalities are not equipped to absorb without additional funding. The result would be reduced transparency, increased administrative complexity, and a potentially unfunded mandate. Thank you for your time and considering the LPC's perspective on this issue.
Thank you very much for providing testimony this afternoon. Are there questions, committee members? Yes, Representative Lee?
Did the LPC have was there any nuance to the individuals covered by the bill with respect to the LPC's opinion? I mean, if it were a narrower bill that say just applied to judicial officers, would there be a different opinion?
I don't believe so. I think their opinion would be the same. They did mention that they would also like to have that immunity. So I don't think narrowing it would change their opinion.
Representative Caruso.
Thank you. Thank you for your testimony. If it was not unfunded, how would that affect their decision, do you think?
Well, if there was funding to go along with all the administrative burdens, I think they would be more receptive to it. Thank you.
Additional questions, committee members? One quick question for you. Did the committee discuss at all the possibility of, rather than a municipality doing all this legwork, having a platform that engages in scrubbing, do the work?
They did not. I didn't realize that that was part of the bill at that time. So they did not discuss that, but it is an interesting concept.
Okay. Would you have an opportunity to discuss that and bring information back for the work session?
I could certainly ask them, yes.
I can see that it would make a vast difference on the workload of a municipal office.
For sure.
Okay, thank you.
Thank you.
Anything else, committee members? Seeing none, thank you.
Thank you.
If you are participating online and you wish to speak in opposition to 2121, please raise your electronic hand and keep it raised until you've provided your testimony. There are none. And finally, is there anyone in the committee room who wishes to speak neither for nor against? Seeing none, is there anyone online who wishes to speak neither for nor against? If so, raise your electronic hand. There are none. Are there any legislators who wish to provide testimony on this legislation?
And I'll recognize Senator Carney.
Thank you very much, Representative Kuhn, members of the committee. I'm happy and sad to be here today to talk to you about this bill. I want to speak in support of LD 2121. Like Senator Bailey, I was one of the legislators who received that threat. I will just briefly describe it to you. It was around 6 o'clock in the morning. It was in the winter. It was still dark outside. I was sitting in my pajamas in my kitchen, getting ready for the workday, reading through emails. And I saw the caption of the email that said, "You're going to die." and then the body that said, "I'm going to kill you and all of your child raping friends." And it really shook me to my core. I have received threats before that are face-to-face threats to be shot right in the head, actually. And but the person who did that, who made that threat, was somebody who was known to me. I knew the make and model of car that that person drove. I knew what he looked like. And so I was able to take some basic steps to protect myself, to speak to the local police department, to let my family, including my teenage son, who at that time was living at home, finishing up high school, let him know that if he saw a truck that looked like this or a person that looked like this, that he should hide and call the police. But when you get a threat of political violence that comes at you over the internet, you don't know any of that stuff. You don't know where the person is. You don't know whether they're, waiting. I live on a dirt road, waiting on my dirt road, hiding in the bushes to shoot me on my way to the State House that morning. I don't know if they're waiting in the parking lot. I don't know if they'll be at that time, the cross office building had no security. I didn't know where this person was, what they looked like, anything about them. And I think that unknown lasted for, I don't remember how many weeks, but there was a long time when we didn't know where this person was from. We came to know that he was in Illinois. We learned at the sentencing hearing that he was somebody who had access to guns, that he had a substance use disorder problem, that he had been engaging in interactions online with groups that were fomenting hate against certain political groups and policy makers. And it was very terrifying. I basically, for the time until we knew that he was in Illinois and that the police had identified him, I didn't know whether I was safe. I didn't know whether my family was safe. Didn't know whether the committee was safe, because when I'm here in this committee room, I feel an obligation to the safety of everybody who's in the room. And it is terrifying. And I would ask that we all work hard to do what we can to protect ourselves and our colleagues and other public officials in our state from acts of political violence. Thank you. And I'm happy to answer questions.
Committee members, are there any questions?
And I will be here for the work session if one occurs to you later.
Thank you, Senator.
Thank you.
Are there other legislators in the room that would like to testify? Okay, not seeing any. We'll close the public hearing on LD 2121. We're going to take a 5-minute break to reset the room and give everybody a chance to stretch, and we'll be back at 2:35.
Very well behaved.
So do you want to go, if you want to sit here? At some point. That's all right.
Driveway, sidewalk, street, sidewalk across the street, neighbors drive.
My name is Ed.
Yeah, I simple by their. Yes. Oh, okay, great. Yes. Yes, okay. Oh, great.
The person. The guy who pulled over. And how you gonna do that?
Committee members, if you can take your seats, please. We're going to open the public hearing on LD 2059, an act to provide required funding for the reimbursement of assigned counsel and to develop the public defender office for Cumberland County. And the bill will be presented by our colleague, Senator Carney.
Thank you very much. I'm just going to wait a moment while Soupy passes out the material. Chair Kuhn and esteemed members of the Joint Standing Committee on the Judiciary. My name is Ann Carney. I represent Senate District 29, and I am honored to be with you this afternoon to introduce LD 2059. It's titled An Act to Provide Required Funding for the Reimbursement of Assigned Counsel and to Develop the Public Defender Office for Cumberland County. This is emergency legislation, and it is a funding bill. That is, there are no statutory changes. It's simply funding for PDS. I want to thank the committee for your thoughtful consideration of this legislation, as well as for the significant public defense work in which this committee has engaged since the 130th legislature. You have worked with the Commission on Public Defense Services, formerly known as MCILS, the judicial branch, the executive branch, and our fellow legislators to build and sustain Maine's capacity to provide Sixth Amendment defense to criminal defendants and parents who cannot afford an attorney. Over the last 6 years, Maine has made significant and necessary changes in our system for respecting the Sixth Amendment right to counsel for indigent criminal defendants and parents in child protection cases. We have worked to establish a series of public defender offices that mirror the prosecutorial offices and to improve reimbursement rates for assigned counsel who remain an important part of our public defense system. Last week, Executive Director Freyla Tarpinian presented to the committee the annual report of the Maine Commission on Public Defense Services. E.D. Tarpinian's report and presentation outline the meaningful headway Maine is making, and I'm grateful to the dedication and hard work by E.D. Tarpinian and Deputy E.D. Maciag. The recent sharp decline in the number of cases on the unrepresented list is reflective of the substantial progress made under the leadership of PDS. And I would also give recognition to the former executive directors as well. They have developed a new process described on page 5 of the annual report to assign counsel for unrepresented defendants. In December 2024, the unrepresented list had reached a high of 1,053 cases. At the end of 2025, the unrepresented list had decreased to just 252 cases. Still, to paraphrase Robert Frost, we have promises to keep and miles to go before we sleep. We are at a critical point in establishing a statewide public defense system. 5 offices are operational and a 6th is underway. The number of attorneys renewing their eligibility to serve as appointed counsel has increased steadily over the last few years. Passing LD 2059 as emergency legislation will sustain PDS through the end of this current fiscal year. Failure to pass this funding bill, on the other hand, will prevent PDS from paying bills to assigned counsel in the 4th quarter, likely leading to a soaring number of unrepresented individuals once again. I truly fear that this will take us back to the conditions that led to the Robbins v. State of Maine litigation in 2022. As E.D. Tarpinian stated on page 6 of the most recent annual report, these unstaffed cases create inefficiencies within the system that impair all sides from resolving cases. which is costly both in terms of monetary resources, but also in the burden placed on indigent clients and the human capital of overworked systems. And as a reminder, those systems include the public defenders, the prosecutors, the court staff, and the individuals involved in these cases on both sides, those who are accused of crimes and those who are victims of crimes. Our growing public defense system has become a stable foundation for providing public defense services across the state. The brick and mortar offices and attorneys employed by PDS enable Maine to comply promptly with the Sixth Amendment and the flexibility to respond to demand throughout the state. The continuing legal education training opportunities, the research tools, the resource counsel provided to PDS attorneys and to assigned counsels are yielding the effective professional representation our state needs. And we have seen, especially in the most recent PDS annual report, that nurturing our PDS system will lead to significant cost savings for the state, as well as timely, consistent, and quality representation for indigent defendants and parents in child protection cases. LD 2059 is urgently needed to meet the state's obligation under the Sixth Amendment. This emergency legislation will keep PDS system functioning in the last quarter of this fiscal year and support our progress toward a more stable, reliable, and cost-effective system in the near future. I urge you to support LD 2059, and I thank you for your thoughtful consideration. I'm happy to answer any questions you may have. I also promise that I will be here for the work session.
Thank you. Are there questions for Senator Carney?
Thank you, everyone.
Not seeing any. All right, do we have any co-sponsors here in the room who would like to testify? Not seeing any. We'll move on to members of the public who would like to testify in support of this legislation. Just put them right in the basket. Sippy will grab them. Thank you.
Thank you. Good afternoon, Chair Kuhn, Chair Carney, distinguished members of the Judiciary Committee. I probably know my name at this point, but my name is Freyla Tarpinian. I'm the Executive Director of the Maine Commission on Public Defense Services. I'm going to take you back to a moment in my life that's really important, and that was December of 2012. We got an email from what was then MCILS stating that they were no longer paying vouchers. My heart sunk into my stomach. I went into my office and sat down, and I remember the sense of betrayal and the fear. I had staff that I had to pay. I had quarterly pay taxes due at the end of the month. It was the beginning of the year, and I had to pay my malpractice insurance and rent. And I went home and walked into the house and said, I'm canceling Christmas. We're not doing it this year. We're going to pull in, we're going to make it work, but we don't know how many more weeks we're going to go without paycheck, because I was a substantial contributor to my household, and my household wasn't going to function. We had to pay the mortgage. We had to stay fed. We had to get our cars running. We had to pay the basics. We had to heat our house. It was the middle of winter. My heart goes out to the solo practitioners and the attorneys that make up our workforce, the people who do the work of PDS every single day, who we rely on for the vast majority of cases. And I'm urging you to support LD 2059 so that we can continue to support folks right now, so that they don't go through that same feeling that some of them have felt before, but that they continue to work for pay, that they have made a deal. They take less money for these cases than they do for their private practice. And the expectation is they'll have a little bit of security that the payments will come in so they can sustain their practice. I won't go through my entire annual report. The importance of this bill, it's an emergency legislation that will allow us to pay the bills on time. If we get a supplemental allotment, that would allow us to pay the bills. That's not going to come until midsummer. That means that payments will not be made in the fourth quarter. That starts in April. That is one of the significant advantages of this bill. The reason we're here, we had a $150 rate increase from our $80 increase, but our baseline budget did not increase with that. That was not an oversight. That was a known fact at the time. We also, in addition to that, had a $10 million deappropriation in fiscal year 24 and 25. That is the substantial bulk of this money that is missing at this point. Finally, if we do wait until July, the bills are going to cost more and we're going to waste money paying people late fees and interest on bills that would have come due and should have been paid on a timely manner, which would be better for everybody, for PDS, for the state of Maine, for the taxpayers, and for the folks doing our work. At the end of the day, this legislation is really, really important and critical to ensuring PDS can continue to provide the services that we provide every day. Thank you.
Thank you. Are there any questions, committee members? Senator Hagan?
So I just have to claim ignorance. I don't know much about anything. So this is a problem just for Cumberland County, no other county?
Oh my goodness, no. This is a statewide problem. Right now, the current county with the biggest problem is Aroostook County.
Okay, so I must have misread the thing. I thought it was just for the Cumberland County.
No, we're a statewide agency. This money will fund attorneys in every single county and area in this
All right.
entire state.
One last one.
Yes, go ahead.
So I'm curious, visuals are always good for me. Is there a, like a chart of the counties and the undone cases and the costs and the number of PDS attorneys and all that kind of thing?
The annual report has some of that, but I don't think that's overlaid the way it is. There's a chart in the annual report that shows how many attorneys are in each of the counties and the regions in Maine, so you know where the numbers of attorneys are located. In terms of exactly how much payments we made to each county, we didn't break it out that way, but I can look back and see if we can get you that information.
That'd be great.
Yeah, absolutely.
Thanks.
Representative Crusoe?
Just following up on Senator Hagan, I was just looking at the bill title. It says Cumberland County, and in the summary, it says Cumberland County, but so it's your understanding this is not just for Cumberland County?
There's two parts of the bill. The first part is funds the shortfall. So that's a $13 million appropriation that will allow us to pay our bills this year and this fiscal year, which ends on July 1st. The second part of the bill is a build out of the next public defender office in Cumberland County. We were given some attorneys led by this committee last year in LD 1101, and we've used those attorneys in Cumberland County because there was critical need at that point in time. But it's not a fully functional, fully funded the way the other offices are funded, like PD office. This would be the next public defender office if we're trying to create a statewide network. And the reason for that is market stability. We want to have a baseline of attorneys in every region so that there's no region that's not met. But then we're going to look at allocations of where the resources are needed. So I think I said at the annual report, I suspect Aroostook County may need more attorneys because there are fewer private attorneys available there than in Cumberland County. We may need a lower proportion of attorneys in Cumberland County because there are many attorneys in Cumberland County that do our work. So this bill just establishes that office, but more importantly to us funds that shortfall.
I'm going to ask the bill sponsor to just provide clarification on your question. Senator Carney?
Thank you. And I wish I had included this in my remarks. I was intentionally vague because at the time that my bill request was filed in September, Cumberland County had the greatest need. And that is where the attorneys who were hired to help deal with the unrepresented list were working at that time. But one thing that we heard in the annual report last week was that there may be a greater need for example, an appellate division or to help balance out other needs in other areas. And so I just was kind of vague and I apologize for that. I should have clarified at the time that I presented the bill.
Representative Poirier?
Thank you, Madam Chair. Thank you so much for being with us. I realize that this bill is to have money for the assigned counsel, but part of my understanding of why there's such a need on that, I would like to know, and maybe you've provided this in reports and you can direct me to it, but I'd like to know perhaps by district or what have you, how many cases each PDS person has on their caseload, and also what kind of things PDS as a whole is doing as far as any cost saving measures that you might be able to find within your budget.
Absolutely.
Representative Lee?
I'm trying to jump into my memory, and that's never an easy thing to do. I think you said in your testimony, this is an anticipated shortfall because we underfunded in the last budget.
That's correct.
And I remember it wasn't you, but it was Mr. Billings who came to us and told us that we would have this shortfall. Is that accurate from your recollection?
That is correct.
I had a question for you. You described in your testimony the impact on practitioners if their bills aren't paid. I wonder if you could describe for us what you would expect the impact to be on the unrepresented list and on individuals needing representation.
Absolutely. My fear would be that if attorneys are forced to look for other ways in order to get their needs met, so that they can pay all their bills, that they would reduce the cases that they're taking for PDS, which would mean take less of our cases. That's less protective custody cases for parents' rights, and also less criminal defense cases for folks who are incarcerated or who are facing criminal charges, and would need to fill that need with other types of cases. And so my fear would be a reduction in the number of cases that people are taking, and that could look like they leave the practice altogether and establish a different type of practice. Or if an attorney who is currently doing a substantial portion of our cases changes half of their caseload to take on private clients to make up for that shortfall, to bring in income right now to so that they can pay their bills on an ongoing basis, that's going to be a 50% reduction in the number of cases that person would take moving forward. Now, if that person takes 5 cases, that's not a huge deal. But if that person is taking 20 or 30 cases, that is a substantial hit to PDS's ability to staff cases. And remember, cases don't resolve very quickly necessarily. So if you take on a new client who's a private client and for a different purpose, you're with that client, your capacity is taken until that case is resolved. That can be months, it can be years. Ultimately, we also are finding recruitment issues. So we have a lot of folks who are young attorneys or new attorneys in school, externing and interning with us. I also fear that as they learn that there may not be money for them to be paid, that may be an economic decision they make. If they're going to set up their practice, let's say they're going to graduate in May and they take the bar, if they're going to set up their practice next fall and they're thinking in their head, we know there's a shortfall coming in 2027 right now. Maybe I'm going to look at family law. Maybe I'm going to go towards a type of practice that maybe I can do law adjacent, but is going to sustain me and my family, because nobody wants to set themselves up after they've taken on usually a large amount of student loan debts. They have to sustain themselves. And then also facing this insecurity with funding can be a disincentive for folks to do our work. And that's either as a PDS employed attorney or not. We want people engaged in criminal law and parental defense so that we can meet the needs of all the minors that need counsel right now. We don't want to disincentivize anybody who's interested, no matter how they want to enter our system.
Thank you. Any other questions, committee members? All right, not seeing any. Thank you.
Thank you.
Will the next person in support please step up?
Stay. Do you have the copies, or have they already been distributed? The testimony? Wonderful, thank you. Perfect, thank you. Senator Carney, Representative Kuhn, and distinguished members of the Joint Standing Committee on Judiciary, greetings. My name is Emily Elmore, and I am an indigent defense attorney serving as assigned counsel in York and Oxford counties. I'm also a retired Air Force officer. I am a combat veteran. I served nearly a decade as an Air Force pilot until an injury resulted in my medical retirement. And here is my friend Louis, who you may have seen around the state office, and he is the reason for that. I'm here today to urge the committee to support LD 2059 and fully fund the reimbursement of assigned counsel, which is critical to the functioning of Maine's criminal justice system. To be clear, this bill does 2 things. First, it is going to provide funding for the reimbursement of assigned counsel across the state. So I practice in York and Oxford counties. I don't practice in Cumberland County. I'm not a part of the public defender system. I can't speak to that in particular, but that is the second part of the bill. To the former piece of this, I want to urge you to pass, certainly. I want to share my story a little bit with you, just so you understand why this is so critically important. I was medically retired from military service, but I was not ready to stop serving my community. With my husband and my 2 small children by my side, I used my GI Bill to retrain as an indigent defense attorney. It is an area of critical need in Maine. That is where many of you first met me, of serving as a legal intern in the Maine Senate last session. Since then, I did what I set out to do. I graduated from law school in May, I passed the bar in July, and I have been an indigent defense counsel since October.
Today, my ability to continue that service is once again at risk. As much as I value this work, and I set up my entire second career to serve the communities of Maine doing this work, I also have a responsibility to my family. Assigned counsel carry the full financial burden of their practice, and extended uncertainty in state funding is simply not sustainable. Although reimbursement is below market rate, we can work that because it's economically viable. This body did that. You increased the rates to $150 per hour, but prolonged gaps in payment will not be. The funding in LD 2059 addresses a budget shortfall that arose because recent reforms are working as intended. The legislature increased reimbursement rates to address a severe attorney shortage and an overwhelming case backlog, and the policy is succeeding. Senator Carney mentioned the unrepresentative list has shrunk. Appointments are being filled, cases are moving through the system, attorneys are joining the roster. Increased voucher submissions do not reflect excess spending or mismanagement. They simply reflect representation being provided where it previously was not, and this was expected. Failing to fund the shortfall will have immediate and predictable consequences. Assigned counsel will be forced to reduce or cease indigent appointments, not out of preference, but simply out of necessity. We will have to shift towards private clients to meet our fixed operating costs. That shift will require substantial reinvestment in practice infrastructure, and once that occurs, participation in appointed work is unlikely to rebound, because at that point, attorneys will have committed their limited time, staffing, and professional capacity to private caseloads that cannot be readily displaced. For these reasons, I respectfully urge the committee to support LD 2059 and ensure full funding for the reimbursement of assigned counsel. Thank you for your time and your consideration. I can address any questions if you have them.
Thank you for your testimony. Are there any questions, committee members?
Thank you.
Not seeing any. Thank you. Will the next person in support please step up?
Good afternoon, Senator Carney, Representative Kuhn, members of the committee, Representative Lee. My name is Jim Hawanik. I'm from Lewiston. I've been practicing criminal defense for over 40 years. I've represented over 10,000 people, primarily in the Androscoggin County area and southern Maine, in some of the toughest demographic districts in the country. I got 3 murder trials between now and July 1st. One in Bath in February. I've got one in Augusta in May and one in Bangor in June. And that's going to take up, needless to say, a lot of my time. The one point that I did want to make is in the 40 years that I've been doing this, one of the most significant changes that I've seen is how costly this litigation is. As recently as 2004, I did the Francois Gallant murder trial for less than $5,000. The trial that we're going to do next month in Bath, Tyler Witham Jordan, I already have $75,000 into it. We've got experts coming from out of state in the tens of thousands of dollars, DNA experts from Texas, medical examiners from Utah. We have 3 defense lawyers. This is a case that we tried, the McKinsley Hanrahan murder in Edgecombe. We tried that a year and a half ago, and we're relitigating it now because the prosecution made a serious mistake that led to a mistrial. So there's upwards of $500,000 in litigation costs in one murder case alone. And it's not even our fault. This is a case that the prosecution messed up, and now we have to retry it again. We did a shaken baby case in Auburn last year. 17 medical doctors testified. These are cases that cost hundreds of thousands of dollars to litigate now. And 20 years ago, I was doing these for $5,000. So it's very expensive. It's just expensive. That's all. It's that simple. Complex DNA science, the shaken baby case, learning about subarachnoidal hemorrhages. You have to become almost a med student as well as a lawyer. So I can assure you that I speak on behalf of the vast majority of the defense bar that we're extremely grateful for that raise we got a couple years ago. I really think that it really stopped what was going to be a major constitutional crisis. But we've still got a little ways to go here. If we can fill up this last quarter gap, I think we're making great progress. Frayla's doing a great job since she's come on board. We've got a lot of hardworking criminal defense lawyers across the state who are very committed. And
If I could ask you just to wrap up your
Yeah, I'm
testimony
sorry.
in a
And
sentence or so.
that's all I have to say. Thank you.
Okay. Thank you. Committee members, other questions? Representative Lee.
Thank you for being here, former mayor of Lewiston. I had a question just about a portion of your testimony. You said you had $75,000 already into the case. That's $75,000 that you've worked that you have not been compensated for?
Oh, no, this was from the first trial.
Okay.
Yeah, and now we've had to, I was just getting out, I just got out 67 subpoenas for the next round of litigation that's starting in 3 weeks. Yeah. And
that's essentially work that you front.
Yeah, we litigated a 2-week trial that ended in a mistrial about a year and a half ago. A little 3-year-old girl who was killed on Christmas morning, a horrible case. We think the state police have the wrong person. And, the police make mistakes sometimes, and we're the ones who get to challenge the government. And at least from our bias perspective, that's a pretty important function.
Any other questions? Thank you for your testimony.
Thank you.
Got a lot of people waiting to come up here. Thank you very much. My name is Donald Alexander. I'm in Senator Carney, Representative Kuhn, members of the committee. I'm here today to testify in favor of adoption of 2959. I wish what I could do was simply take Senator Carney's testimony, Frayla Topinion's testimony, the other testimony you've heard, and incorporate it by reference, because I agree with all of it. And I'm going to cut down some of what I said, which repeated that. Because I'm supporting this bill because it's really essential to help continue and assure the progress that's already been greatly made. The report you received last week showed a number of very important changes. The great reduction in the number of unrepresented people on a daily basis. The substantial increase in the number of attorneys volunteering to take cases both on the general assignments and on the specialized assignments. The new ways to pay attorneys and to check their work, which is all important. To say, and you have my testimony somewhere, and all that's critical to the process. And as has been pointed out, the last couple of people talking, most of the attorneys that are doing this work, and we're talking about assigned counsel work now, not the public defenders. Most of the attorneys doing this work, including some of you, are solo or small firms. They need that income come in constantly to support them, their families, their practices, and all. And if that's cut out, a lot of them may be having to find other things to do, and all the progress we've made is going to disappear and disappear soon because of those attorneys who have committed to us, increased their work they're doing, and all, and doing mostly a wonderful job. We need those people to keep going, and the only way they can do it, because they have families, they have debts, they have college, due and things like that, is to keep their payments coming regularly as they must do, and to support that process. We've covered a lot of money this year because we've been successful in getting a lot more attorneys to do it. So our expenses are high, but we need to continue that. And to do that, we need the LD 2059 supplemental appropriation and support for counsel. That's got to happen. We have signatures of our progress. The Boston papers now are reporting that, the Sixth Amendment Center, which attacked us, now is saying Massachusetts ought to be like us. We've improved that much. And that's in part thanks to you all for the appropriation, the increase of money we had. And I see that my time's up, and you have my testimony somewhere, and I'll be happy to take any questions.
Thank you. Are there any questions? Representative Blake?
Occurs to me, I should have probably asked Ms. Elmore this question, but I'm curious what it looks like for folks who are at the beginning of their career and are serving as assigned counsel right now, knowing, and I've probably tortured this analogy, that we're building a house at the same time as we're trying to put a fire out in the house that we live in.
Yeah.
At what point, from your vision, do we move away from people actually having assigned counsel as their primary job?
I don't know that we ever do that, because Maine is such a big state with such diverse interests, with such, important needs. And with the reality too, that a lot of times in cases with multiple defendants, there's conflicts of interest. You think of child protective cases. I don't know if you do any of that work, but, last time I looked, right before the pandemic, 39% of MCPDS costs were child protective cases. In that case, if you have the mother, the father, and a guardian ad litem, you need 3 attorneys. Only one of them can be a PDS attorney. And so it's difficult to challenge. New attorneys coming in have it better off now because we have a superb training and mentoring system, which is aiding that, making it more comfortable for them, is one of the reasons that support, along with our quicker payment process, is one of the reasons that supports what we've done, the increase in number of attorneys doing it, and the great progress we're making in meeting the constitutional requirements we have.
Any other questions?
Thank you.
Thank you.
My name is Edward Kane, Senator Carey, Representative Kuhn. My name is Edward Kane, and I should have brought something. I said to myself, because I've been a lawyer in Maine for about 40 years, and at the very beginning of that, I had the honor of being House Chair of this committee. And it was, I don't want to say my life's gone downhill since, but it's, but I enjoyed it. I enjoyed every day of the legislature, every episode, every single day. And I'll try to make this very brief. As one guy used to always say on the floor, he said, very briefly, Mr. Speaker, every time. But I really do think I'll make a couple of short points. One is, this isn't optional. Constitution requires it. It's going to have to be done. There's no way out of that. So it's really just a question of timing. When is the payment going to be made? And is the payment going to be made in a way that that to these people taking these court appointments, they that conveys that everybody's collaborating on an atmosphere of dignity and professionalism and comedy? Or does it convey in something very different, which was that it's really not very important. This really doesn't count that much. And we're going to treat this with dismissiveness. I really do think that's what it is. Like I said, I've had a career that has not been criminal law oriented. And so the fact that I'm doing this now is utterly dependent on my working with mentors and who are really deeply experts on criminal law. But as has been mentioned before, a lot of these people, they can just turn off the $150 an hour business, and they can just go on straight retained business. And there's not less of it than there used to be, and people are willing to pay when they're in those kinds of circumstances. So that's I think your real option. You can't save any money here, but you can send a message that helps FRELA and the commission build a culture that is going to be collaborative and that's going to get the kinds of results that you want. I'll mention one guy who he's not only very, very deeply expert, he's so extremely efficient. I mean, he can just mow through cases like corn just because he's so expert. He just sees everything. And before it happens, wonderful relationships with the prosecution, with the bench. And he said, if this, he just doesn't see it. He said, his attitude is, who else would who else would get this kind of treatment? And I think I'll just go straight. And so I think he's a perfect example. Now, you're not going to be able to measure that. You're not going to get that on a graph or a chart from the commission. Very, very high quality people, very dedicated, are just going to say, I just can't do it now. I'm just going to go to privately retained business altogether. And I think that's about all I have to say, and I'll be happy to answer any questions.
Thank you.
All right.
Are there any questions, committee members? Not seeing any. Thank you.
But I will live up to that IOU, and I've already talked to Senator Kerry about where it'll come from.
We appreciate that.
Good afternoon, Senator Carney, Representative Kuhn, members of the Judiciary Committee. My name is Matt Morgan. I'm the president of the Maine Association of Criminal Defense Lawyers, or MACDL, and a private practice attorney here in Augusta at McKee Morgan. MACDL supports LD 2059. The Maine Civil Liberties Union filed suit in Robbins v. State back on March 1, 2022. At that time, the Maine Commission on Indigent Legal Services, or MICLS, was the entity providing criminal indigent legal services. It was doing its best, but it had failed to implement several long-standing requirements around supervision and training of appointed attorneys. The courts were, and in many places still are, struggling under massive backloads of cases stemming from the COVID-19 pandemic. In short, the number of appointed attorneys taking cases was going down, while the number of cases pending was going up, and it was a crisis. And at that time, one of the primary reasons was that the $80 hourly rate paid to appointed attorneys was woefully inadequate. Significant progress we've heard about from people speaking before me has been made since March of 2022 and has been profound in some places. Training and oversight standards have gone into place. Backlogs have been reduced. And most importantly, the number of people in jail without attorneys has been reduced. The funding of an adequate hourly rate of $150 for appointed attorneys is without question the primary reason that that progress was made. We thank those members of the committee who supported that at the time. The Public Defense Service Commission, the attorneys it employs, the attorneys it contracts cannot afford to lose this progress. The state of Maine cannot afford to lose this progress. The current $12 million budget shortfall is a truly existential threat to this progress. LD 2059 is a necessary emergency measure to maintain the status quo of providing constitutionally adequate criminal representation under the Sixth Amendment. If this budget shortfall is not addressed, then we will find ourselves back where we were in March of 2022. For all those reasons, MACDL urges you to vote that LD 2059 ought to pass. Thank you.
Thank you. Are there any questions, committee members? Not seeing any. Thank you for your testimony. You're welcome.
Hi. I don't know if you want to restart the.
Oh, yes. Thank you for that reminder. Go right ahead.
Good afternoon, Chair Carney, Chair Kuhn, and members of the Judiciary Committee. My name is Lily Wilson, and I am a second-year Maine law student, where I'm the chair of Students for the Sixth Amendment, a group dedicated to advocating for the protection of Sixth Amendment rights, as well as providing educational and networking opportunities to students interested in the topic. This past summer, I was also an intern at the Lewiston Public Defender's Office, and I'm here today just to speak on behalf of myself, but through conversations with many of my peers in support of LD 2059. I decided to apply to Maine law in 2023 while working downstairs in the Senate President's office as MICLS became MCPDS. Watching that process move through the legislature is what catalyzed my choice to apply to law school. I applied only to Maine law because I didn't just want to be an attorney. I actively wanted to be a part of building a more sustainable and just indigent defense system here in the state I call home. Since starting law school, that's only become more true. I'll forgo talk of the moral, ethical, and constitutional imperatives of upholding the Sixth Amendment because I know the members of this committee are well aware of them and act frequently to make them manifest. What I do want to share is the perspective of a law student considering what her rapidly approaching legal career will look like, especially in light of the fact that all the enthusiasm and commitment in the world won't pay for student loans, insurance, rent, or a mortgage.
I'll graduate law school with about $80,000 of debt from my undergraduate and law school loans combined. I don't think that's an uncommon amount for many law students. It's not a number I say out loud very often, but I do think about it literally all the time. Some comes from undergrad, but most of it, the vast majority, comes from my law school debt, which comes after about half scholarship for my in-state tuition, as well as a part-time restaurant job. For the first 2 months of school last year, I worked about 3 to 4 evening shifts a week against the advice of many previous law students. I thought I could do it. Turns out I couldn't. I started to fall asleep in the afternoons in class. I was so tired. My notes would be scribbles. I had to come to terms with the fact that the reality was I needed to take out more loans to support my cost of living. I continued to work that job just 1 or 2 days a week, as well as through the summer while working for MCPDS in Lewiston. That was a really, really tough call, but I think is an example of myself and many other students who do the same thing, being willing to make sacrifices to do this work, both during law school and after. None of this is to say woe is me, or not to say that it's a unique experience. Most students have to find ways to hustle to pay for school. Working at the defender's office was a true privilege. Learning from those attorneys was fantastic. And going to law school is generally a joy. And when I do the math, it's actually totally doable to pay off my debt over a reasonable number of years with a legal job that will dependably pay the bills. The keyword there is the dependability. Not even the possibility of not being compensated with that kind of monthly payment on a debt load is prohibitive to pursuing indigent defense without that kind of certainty. I would fall behind rapidly with major consequences. Additionally, the tension and animosity that scarcity of funding creates is certainly observable to me as a student and as an intern. Alongside the risk of not being paid, this is kind of an element of disrespect that's challenging pill to swallow, even with a lot of optimism and enthusiasm. I urge you not just to support this bill, but to work ardently with your colleagues to ensure that it is funded after passing out of committee. Thank you.
Thank you. Are there any questions, committee members? Thank you for your testimony. Welcome.
Senator Carney, Representative Kuhn, members of the Joint Standing Committee on Judiciary, good afternoon. My name is Zach Hayden. I'm Chief Counsel at the ACLU of Maine. I'm also the lead plaintiff's counsel in Robbins versus State of Maine, a case challenging the state of Maine's denial of counsel to thousands of people who are entitled to it under the Constitution of both the state of Maine and the United States. I come before you for the reasons that everybody before me has said. This is a really important bill. I urge you strongly to support it. It is a matter of constitutional necessity. Lawyers in criminal cases, as the U.S. Supreme Court said in Gideon versus Wainwright, are necessities, not luxuries. I know that budgets are tight and spending is difficult, but this is truly one of the most important obligations that the state has. I'll just add that, in April 2019, when the Sixth Amendment Center report came out, it documented a wide range of problems with the way that Maine was attempting to meet its Sixth Amendment obligations. And when we filed suit in Robbins nearly 4 years ago, we laid out a whole range of problems that the state was having meeting those obligations. Maine is on the right track in addressing that. As Senator Carney mentioned in her opening, the numbers of unrepresented have come down significantly, but there are still more than 200 people who are without counsel entirely. And that says nothing about whether those counsel are being properly supervised and trained and evaluated and supported. But the reason why Maine has made such progress is the leadership of this committee, and in particular, setting up public defenders' offices across the state. It's been the single most significant development in the way that criminal law is practiced in Maine in decades. And you have a lot to be proud of for that work. And I, as somebody who's spent an enormous amount of time on this issue, really am very appreciative of all that you've done and hope that you'll continue to be the leaders for this legislature and for the state on this issue. Happy to answer any questions.
Thank you. Are there any questions for Zach Hayden? I'll ask a question, similar to what I asked Perla Tarpinian earlier. We've heard from practitioners the impacts of unstable funding, very understandable. Can you describe a little further the impact on the unrepresented list that you would anticipate and on the individuals who are waiting for representation?
Yeah, it's a great question, and I'll answer it in two different ways. What those delays in payment mean is often delays in appointment. And what delays in appointment mean are both harm to somebody's legal case and harm to their personal existence. So the reason why it's harmful to their legal case is crime scenes are altered over time. Witnesses' memories fade. People don't have a chance to interview a witness. They don't have a chance to ensure that evidence is preserved. There's a lot of evidence, as Mr. Hwaniak talked about, a lot of evidence is electronic. It's, you know, and unless somebody's taking steps to make sure that evidence is preserved, the defense counsel might not have a chance to help with it. So this was a big issue in our case of making the court understand, helping the court to understand how it harms someone's legal case when there's a delay in appointment. But that harm, to me, I think is sort of even less significant than the harm to somebody's personal life. Somebody who's been charged with a crime and doesn't have a lawyer to turn to for guidance. They don't have anybody to tell them what's going to happen next. Where's their case going? They don't have anybody to help the process move along. It makes it difficult for them to do a job, makes it impossible for them to continue with their education. It's harmful to families. It makes it challenging for people to take care of their children. All of these harms that are, you know, well documented in the social science literature that comes from people having criminal charges hanging over their heads that they have no way of addressing because they don't have a lawyer. Does that answer your question?
It does. Thank you. Are there any other questions? Okay, not seeing any. Thank you. Is there anyone left in the room who'd like to testify in support of this bill? All right, if you're online, please raise your electronic hand and leave it raised until you've had an opportunity to testify. Mr. Lehman, if you can please activate your camera. Go right ahead, please.
Good afternoon, Senator Carney, Representative Kuhn, distinguished members of the committee. My name is Peter Lehman. I'm here for the Maine Prisoner Advocacy Coalition. Indigent legal defense is an emergency, not just this bill. This is an emergency. And we want to come here and speak up, not for all the legal issues, but for the lives involved of the defendants and the victims with their lives placed on hold. Whole families waiting. This is not an abstract issue. This is a personal issue. Whole families are waiting. Every day of these, in their everyday lives, these constituents of yours aren't defendants. These are mothers and fathers and children and aunts and uncles. Accusation is a powerful thing. People lose lives. People lose their homes, their cars. These are mothers and fathers and children and aunts and uncles in crisis. I want you to remember that. This is not an abstract issue. This is a personal issue, and that's an emergency that begs for your attention. Please help by unanimously supporting LD 2059. I also was going to attach a graphic that I've also submitted as a testimony. I was going to submit that with my testimony, simply talking about the lack of counsel at an initial appearance, and that even just the initial appearance
which is what you're jeopardizing if you don't pass this bill, is longer pretrial detention, loss of housing and income, coerced confessions and uninformed waiver of rights, harm to families and children, trauma, violence, injury and illness, worst case outcomes, pleading guilty without a lawyer, all of which end up being in the long run a waste of taxpayer resources. So please remember that this is a very personal issue. Senator and representatives, these are your constituents. All of the people involved and the people hurting and the people being harmed here are your constituents by definition. Thank you. I appreciate it. I apologize for not being there today. I usually am, but just couldn't do this.
Thank you. Are there any questions, committee members? Not seeing any. Thank you for your testimony.
Thank you.
Robert Ruffner, you are next. If you could please. Oh, there you are. Welcome.
Good afternoon. Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee. My name is Robert Ruffner, and I'm the director of the Maine Indigent Defense Center, which is a private firm that does indigent defense out of Cumberland and York counties primarily. I think that Director Tarpinian, Commissioner Alexander, and other people have testified as to the effect that this may have on the state of the rosters for PDS and the corresponding effect on the needs council list. I thank Mr. Lehman for bringing up and Attorney Hayden for bringing up the impact this has on individual clients, individuals waiting for representation in criminal cases or child protective cases. I want to talk about the human cost this has on my family. And by my family, I mean the 23 individuals that I'm responsible for providing for, that one way or another depend on my office for their financial well-being and their family's well-being or their educational opportunities that they have. Currently, I have 11 attorneys in this office besides myself that work on PDS cases. We've got 4 full-time support staff, 2 part-time law students that are working in the office, and there are currently 4 law student externs who depend on our office for their current class, so to speak, their credits that they're earning this semester in law school. Our firm, until recently, only did PDS cases. One of our senior attorneys recently went of counsel because he could not handle the uncertainty of the financial shortfall and has reduced the amount of cases he's taking for PDS so he could take retained cases. But the rest of us only do PDS work. If this shortfall isn't addressed, I'm required to shutter my doors. I do not legally have the option to not pay my attorneys, to not pay my staff. I have to lay them off. Not all of them would be able to keep their current cases. Many of them would be searching for other work, and not all of it would be doing indigent defense. We have 6, soon to be 7 children that are not even in school yet amongst the people who are on my staff. A number of them depend on this office for their health insurance, for their for daycare, and it is as a small business. Those are the people that are impacted. It's also the clients. But I'm not talking about me. I'm talking about the people I'm responsible for providing for. Those individuals will be impacted by this shortfall. I see that the timer's going off.
Okay, thank you.
If there's any questions, I'm sorry I couldn't be there today. I couldn't find coverage for court this afternoon, and so have to do this remotely.
Thank you. Are there any questions? All right. Yes, Representative Lee.
Your attorneys practice primarily in Cumberland County?
Actually, I would say most of our attorneys are located in Cumberland, but we are very close to the courthouse, especially since it's consolidated in York County. It's probably an even split and might even be more York County cases than Cumberland. We also have some cases in Kennebec and Oxford County, and occasionally a few other counties when the need arises.
I'm trying to deduce what the implications for the assigned counsel in those counties would be if your office were to shut it.
Well, I'm proud to say that I get to that I have the single largest office of people doing indigent defense work in Maine in one office. If you break up the defender offices to each region, we have hundreds and hundreds of active cases right now, and like I said, not everyone would be able to just open up a solo practice. Some of those people would choose to do other work. We, God forbid, might lose some people to prosecution, which will only compound the problem. That was a joke, but mostly a joke. I don't even want to think about it. When I said that the impact on my family, these are my family. It's my job to take care of them. We're doing this work. We're following the rules. We're billing through the system. And I shouldn't be worried about being able to pay their health insurance and paying for daycare and paying them. I still have 9 years worth of student loan payments to make myself. And I've been doing this for 25 years, apparently. And that's because until recently, I couldn't even make my own student loan payments. It's only recently that thanks to you and the efforts of PDS to get the rate increase, that I could even afford to pay my student loans. All of these other people I'm talking about, they too have student loan payments to make. And it's the short-term effect. I can't fathom the effect it has on people not bothering this summer. We've got somebody taking the bar exam in February, another in July. They're not going to, where are they going to go? It will severely compound the needs counsel list, and at a rate that it would be very, very difficult to recover from.
Any further questions, committee members? All right, not seeing any. Thank you.
Thank you.
Next, Francis Zarro. If you could activate your camera, please.
Okay.
Hello.
Hello, everyone. Thank you, Senator Carney, Representative Kuhn, and distinguished members of the committee. My name is Frank Zarro. I'm a resident of Biddeford, Maine, and I am a principal of Society Impact in Portland. I'm here today in support of LD 2059. Maine is currently the only state in the nation without a formal statewide public defense system. As a result, low and middle income individuals are routinely incarcerated in Maine without sufficient legal representation. Approximately 80% of people facing involvement in the legal justice system cannot afford a private attorney, meaning that the vast majority of Mainers in that category have to rely on the public defense system. Criminal legal involvement can happen to anyone, stemming from a poor decision, a mistake, alcohol abuse, a mental health crisis, homelessness, a child's involvement with drugs, or other unfortunate circumstances. It could befall anyone. Any family could be forced to confront the system. Without adequate public defense, the consequences are predictable and costly. People remain jailed unnecessarily, cases stagnate, guilty pleas are entered not because they are just, but because defendants lack the ability to defend themselves. These failures increase jail populations, worsen court backlogs, expose the state to ongoing constitutional liability, cost the taxpayers money, and ultimately weaken public safety. The Sixth Amendment does not require the state to make good faith efforts, and good faith you have demonstrated. But it requires the state to provide effective conflict-free representation. Anything less undermines the legitimacy of the courts and public confidence in the judicial system. I do not make this point in the abstract. I previously worked with the New York State Defenders Association during what was the Harrell Herring against the state of New York case. It was also an ACLU-led case in which the courts made it clear that systemic delays in underfunding and the lack of access to counsel constitute constitutional violations. That litigation is analogous to the crisis Maine faces today. The key difference is that in New York, that was the 18B assigned counsel panel, which was a supplemental system to support conflicts and overflows from the 62 public defense systems in the state's counties. LD 2059 is a necessary step toward meeting Maine's constitutional obligations. It would stabilize the Indigent Defense Fund and begin the process of establishing a public defender office in Cumberland County where the need is greatest and the impact would be immediate. Maine has an opportunity not only to address this immediate financial crisis and legal defense crisis, but to begin building a truly independent and robust statewide public defense system that could serve as a model for other systems. Expanding services in Cumberland County is a sound place to start. The fiscal benefits of ensuring access to legal representation, regardless of ability to pay, can be substantial. Investing in public defense is not only a constitutional imperative, it is a cost-saving measure. I respectfully urge the committee to support the prompt passage of LD 2059. We attach some sources and references and a lovely speech given by a former colleague of mine, the late Jonathan Gradess, who was a champion of public defense in New York State, which if you get some time to read is absolutely inspirational. Thank you for all the good work all of you do.
Thank you. Are there any questions, committee members? All right, not seeing any. Thank you for your testimony.
You're welcome.
Is there anyone in the room who'd like to testify in opposition to this legislation? If you're online and you'd like to testify in opposition, please raise your electronic hand and leave it raised.
There are none.
All right. Is there anyone in the room who'd like to testify neither for nor against? And anyone online, please raise your electronic hand. Okay, I think we've taken all the testimony on this bill. Close the public hearing. Thank you, everybody.
We're going to change gears a little bit and talk about the public defense report, public defense services report, and but we're going to need about 5 minutes to switch everything around. So we'll be at ease for 5 minutes. Welcome back, committee members. We've got a couple more items on our agenda for this afternoon. One is to discuss the annual report of the Maine Commission on Public Defense Services, as well as the report pursuant to LD 1101, and decide what we're going to do about committee legislation. And then we're going to review the committee amendments to the sexual assault testing kit legislation, which is currently on the appropriations table that we discussed last week. Janet, I will turn it over to you, and also wanted to say we're joined by our legislative analyst, Janet Stocco.
So, the PDS annual report had many things identified as potential legislation in it. I marked them throughout the report when I read through it. But I will point out that many of the suggestions, if you look on page 28 of the bill, it did say that many of these future legislative changes could be done during the 133rd legislature. But there was one item which involved the specifying in law who is responsible for paying court-appointed counsel in certain types of cases. These tend to be cases where it appears more of a discretionary appointment, although perhaps judges always appoint in these cases. I will leave that to the experts. But the way that the current PDS statute is written is it provides that if you have a statutory or constitutional right to counsel, doesn't seem to contemplate any discretion on the part of the judge, then your case would be considered indigent legal services if you are in fact in need if you don't have the resources to pay. And so it's my understanding that the judicial branch and the Maine Commission on Public Defense Services have been talking about, and over the interim, talking about the different types of statutes where PDS may have been paying in the past, but due to financial shortfall reasons, they stopped paying because it might not be clearly specified in statute that they're responsible for those. So the idea was having some legislation, and I could be mischaracterizing this, in which case I hope that they correct my characterization, but having some legislation to clarify that. So that was mentioned in the PDS report. So I spoke to the chairs and they had asked me to work on maybe mocking up what that legislation would look like. So I looked at some information from the Maine Judicial Branch and the information in the report. And I pulled together what that legislation could look like. I didn't give the judicial branch and PDS very much time to review it because we had the holiday weekend. So they may have some technical corrections to the way that the bill is drafted, but this is basically what I understand is being proposed for your consideration. This does not mean I'm suggesting you have to report out this legislation. I just want you to know this is one of the options. And I was asked to show you what it would look like. So this is the salmon colored one. And so the way that it is drafted currently, again, I'll work with the stakeholders to gussy it up, if you will, if you want to move forward, is to clarify in the definition of indigent legal services, which is the definition that sort of drives when the Commission on Public Defense Services, yes, I know you're laughing at me, when the Commission on Public Defense Services is required to pay for the attorney, is to clarify in that definition, in paragraph C, that if a juvenile petitions for emancipation, then PDS would be paying for those attorneys. And they currently are doing that, but this would make it clear because right now it only refers to juvenile defendants and the statute governing emancipation. I have copies of all of them. I didn't hand them all out. I can if you want. But that statute says that the juvenile may ask the court to appoint an attorney. It perhaps isn't as clear about that you have a statutory right to the attorney, which may be part of the confusion for the reason it was on one of the lists of potential areas of clarification. Paragraph C1 would be added, and it would provide that if an attorney has been appointed to represent an indigent respondent in an extreme risk protection order proceeding, this is the new red flag law. And subparagraph 2 would be if an attorney has been responded to represent an indigent restricted person in an extreme risk protection order proceeding under a different title. That's the yellow flag law. And the third one would be an attorney appointed to represent a person who's the subject of an involuntary commitment or involuntary treatment petition. So it's my understanding, at least with respect to the third category, I'm less familiar with their yellow flag and red flag laws, as you know. But at least with respect to the third category, there's been some payment there, and it would be clarifying that that is in fact an obligation to make it clear that that's on the list of not only who PDS must pay, but sort of they have the oversight of that area. And then in the bottom part, only because I didn't know where else to put this, is that indigent legal services would include the services of an attorney appointed under a provision of Title 22. And that provision, let me look, make sure I have it here. Oh, I didn't, of course, bring it. That was the one I didn't bring. Oh, yes. So every once in a while, you know that in child protection proceedings, the parents have a right to an attorney, and if they can't afford one, the Maine Commission on Public Defense Services pays for that attorney. Every once in a while, when the guardian ad litem writes up a report, they might recommend that the judge also appoint an attorney for the minor. So in my very basic understanding, and the experts can clarify this for you, the guardian ad litem's responsibility is to provide recommendations on the best interests of the child, which may or may not align with what the child wants. And so sometimes there is an attorney appointed to represent the interests of the child, and their obligation is to represent what the child is asking for, as opposed to maybe the best interest where there might be a slight divergence. There may be other situations where an attorney is appointed for a child in those cases, but the idea would be that those would also be covered so that PDS would pay for those attorneys. It's my understanding that these are very rare, but if they do happen, PDS would be who pays if you support this legislation, not just to report out as a bill, but later on when you have a chance to vote on it. And then you could see, oh, see, it's right in section 2. I clarified that. I should have just kept reading down the page. So then I put in, just so you could see what this could look like, the language, the disclaimer language is the first paragraph of the summary, which is saying that you're reporting this out in response to the report. You're not taking a position on the bill, and you're wanting this to go through the process. There isn't a statute attached. If you remember, I told you that I didn't give folks very much time to review my draft legislation. And so after I had already copied it, because I did copy it a little earlier than I said I would, there was a suggestion that there may also be another statute that could be amended to clarify when PDS is responsible for paying. So this is a little bit complicated. So you know that there are child protection cases. Those are cases usually, but not always, where the department is suggesting that there's jeopardy to the child. The child might be removed from the home, placed in foster care or a kinship placement. And one of the ways that fairly recently in 2013, this committee amended that law was to say you could resolve that case through a parental rights order. So perhaps if there's a situation where it's one parent that's really posing the jeopardy to the child, and if the other parent were to have sole parental rights and responsibilities or some kind of limitations on the way visitation or something else occurs, that would be sufficient to ameliorate jeopardy and resolve that case. So there is a provision in the child protection laws that talks about the entry of these orders. It's a very necessary provision because child protection cases are confidential, family law cases are not. So it sorts out in current law how you treat the files and what you do when you enter that type of order. But if you look on the second page in paragraph F, it does say that if the court immediately dismisses the child protection action, they are required to terminate the attorney appointments. This is paragraph F, where I put a little arrow and wrote sideways. And then it's also possible that when the parental rights order is entered, the judge might say, well, I'm not ready to dismiss the child protection case right now. I'm going to give it some time. So they could, under the law, give up to 6 months. until the child protection case is dismissed. So it's my understanding that the proposal is to clarify in here that PDS would pay for the attorney in the child protection case to do the litigation about this parental rights and responsibilities order until the child protection proceeding is dismissed. So if you wanted that clarification, that could be in here as well. What I have been told is that PDS is paying, even though the attorneys are working on this sort of parental rights order, it is to resolve the child protection proceeding. So they have in the past taken the position that they will pay for that type of work, but statutory clarity is being asked for here, just to make it clear that even though that's a parental rights order, that particular part of the child protection proceeding can still be billed through the PDS system, is my understanding. Again, the folks behind me can clarify if I'm either way or slightly off in my explanation. So that's my understanding of the request. You have the option to report this bill out as a committee bill and ask that it be sent back to you, have a public hearing and work sessions. If you're convinced by what you read in the annual report and what any questions you ask folks today, that this is just straightforward and just should be done, then you have the option to report out the legislation. I would take the disclaimer off and just say we want it voted straight on the floor. That is your option. Or you could say we're not sure that we can support this at this time. Maybe someone can submit it as legislation next year or another time, but it won't be a committee bill. So those are the options before you on this particular piece of legislation.
Thank you very much, Janet. So questions for Janet, committee members? Yes, Representative Sinclair.
Thank you, Madam Chair. I know we talked about this last year, late last year, in the context of another bill. I don't remember what the resolution of that conversation was, but in looking at the definition of indigent legal services, I'm wondering which of these sub buckets we would put Fifth Amendment counsel into. Because from my reading of these, it doesn't fit any of them, but if I'm misunderstanding, I want to understand.
Okay, first of all, I'm going to admit that I don't remember what Fifth Amendment counsel is. I feel like I just failed my law school exam. But second, I do want to say that there was a bill last session, LD 1796. It clarified some of the questions about who's responsible to pay, and that was primarily directed at proceedings under the Maine Uniform Probate Code. So it clarified that court-appointed attorneys in those cases would be paid by the court. Usually that's the county probate court. They have been paying for those attorneys forever. That's standard practice. Every once in a while, under the Home Court Act, where a child is involved, that case might be in district court. So this was clarifying that the courts are responsible in those cases too, even though they're not in the county court, they're in the state court. There might have been one other child protection provision, but it was primarily about those Maine Uniform Probate Court cases. That's reflected also in this definition of indigent legal services, because this is based on Public Law 2025, Chapter 511, which is the chaptered version of LD 1796. It was allowed to go into law without the governor's signature. I do want to tell folks, because this came up earlier, this is not currently effective because it was allowed to become law without the governor's signature during this session. So it won't take effect until 90 days after this session. But if you want to amend the statute, you have to amend this version of the statute because it will be law when the session is over. Does that make sense? So that's the reason I drafted it that way. That bill also added paragraph E to this definition, which is services performed by an attorney at the direction of the commission. So this might be resource counsel or other counsel, maybe not assigned specifically to a case, but they are helping. There may be other attorneys as well, but that's what I recall the testimony being about. So this is going to be law 90 days after the session is over. So that's the way this is drafted. If you were to put an emergency preamble on it, I would just meet with the revisor and figure out what we would do. As far as Fifth Amendment counsel, can you remind me?
Yes.
So I've only done this in a couple of cases, so my explanation may be less complete than would would be preferable. But Fifth Amendment counsel can arise in any of a number of different kinds of cases. The kinds where I've run into it is, for example, in a criminal matter where someone is called to testify who is neither a defendant nor the other
Yes.
party, nor part of the state, but that person has Fifth Amendment interests that need to be protected because those interests are separate and distinct from those of any party. The court may appoint Fifth Amendment counsel simply to work with that person, make sure they don't shoot themselves in the foot.
Understood. So this is where you might plead the fifth. Now I remember. So are those, I do not know the case law on this. Are they constitutionally required? Has that been found?
I don't know the answer to that question.
Okay, because if they're constitutionally required, they're covered in paragraph A. But if we don't know the answer, it might be worth clarifying. So I defer to the committee's wishes on that.
Maybe just so that we can wrap this up while we're all thinking about it, if Freyla Tarpinian, the ED of PDS, could please join us and answer that question if you're able to.
Thank you. Yes, Fifth Amendment counsel is constitutionally required. The Fifth Amendment's the right to not self-incrimination. If you're called to testify, you have to answer questions truthfully. If those questions could perhaps implicate you in other criminal matters, that would be, you have a right to plead the fifth, which is not to make statements against yourself, but you need warnings, an attorney to warn you of that. So currently PDS does provide for Fifth Amendment counsel when they're appointed in criminal cases. It usually happens right at the time of trial.
Okay, and so that would be covered under
Subsection
paragraph 4A.
That's
Right. Okay, great. Thank you. Any other questions on that topic? Thank you for helping us clear that up. Other questions for Janet, committee members? Yes, Representative Sinclair.
This isn't another question, so if it falls outside of what you're inviting, Madam Chair, I'll withdraw it, but I'm just a little bit uncomfortable. I respect what ED Tarpinian has just said, but 4A seems to cover legal representation provided to an indigent defendant in a criminal case. It's not clear to me that that would cover a non-party. It's possible that the parsing of the ors can be construed to cover non-parties, but it's not clear to me.
So it's possible that could be fixed if you want more clarity by putting criminal or in front of civil case, criminal or civil case in paragraph B. Oh, right.
Yeah. Representative Sinclair.
Or witness.
I was thinking maybe in bucket E, and changing at the direction of the commission, just adding or court. Because Fifth Amendment counsel does aid the commission in fulfilling the commission's purpose. But wouldn't run into, then they would be expressly provided for, is what I'm intending.
Representative Lee.
I might look to you and Freyla to answer this question, but if we were to just change in A, defendant to person, are there other instances in which the Constitution provides protections that we wouldn't want to pay?
I think they could be in
For
a civil
counsel?
case testifying.
And Fifth Amendment counsel would be appointed in that instance.
Yeah, just to ask a general question to the committee. And we could ask Freyla Tarpinian to weigh in on this, but do we agree that we want to clarify that Section 4 of 1802 includes Fifth Amendment counsel for non-parties to civil or criminal cases? Is that something? Does anybody feel that we shouldn't do that? And that is what the ED has told us is constitutionally required and is something that currently PDS is covering. Yes, Representative Lee?
My instinct is to be careful about how we do that, because I could think of scenarios in which it may not be constitutionally required that someone have indigent counsel have appointed counsel in a Fifth Amendment context, but it may not be constitutionally required. They may just be, I don't know, overly cautious or paranoid about the criminal implications. And the court may say, hey, that's not constitutionally required counsel in this instance. And so that's why I'm sort of, rather than opening up the floodgates, I would want to keep it narrow to the constitutionally required component.
Yeah, and what I'm trying to do is to get a sense from the committee as to whether, because it's hard to wordsmith on the fly and you might need to vet it with a couple people before voting on it. But if that's a direction that we wanted to go in to clarify the duty that is currently being performed by PDS. And I'm going to invite Freela Tarpinian back to the horseshoe to give us comments on this.
Thank you. I would have a question about whether you would want that person screened for financial eligibility. I think that would be the gatekeeper. That was my first question, which is, would you, because right now we don't think it happens because it's usually on the morning of trial and there's like a call, like, and so we authorize it because it's absolutely necessary. We read this to authorize it. If the committee wants to clarify that, I welcome clarification. We're happy to discharge whatever duties you want us to. So clarity would be welcome. I would just, my one question would be, is there going to be a financial screening component for all of our other cases? We have that. That's indigent. We used to be part of our name. But that would be my only question, which is for your consideration.
Right. And so the impact of requiring the screening might actually be that the person isn't eligible. And then would the trial be delayed or what would happen in that instance?
That's a very good question.
Okay.
I think a judge in that moment cannot provide legal advice. Would probably appraise that person of their rights to a counsel. At the moment, I don't think that happens. Having been through a few trials where this happens, it's very quick. And I think the overriding interest in making sure for the court, making sure that person has service overrides the requirement that person stop the trial so that person gets screened. It happens the morning of trial at 8:30 in the morning. Parties come in, a motion in limine is often filed. This issue is raised right then, and the judge deals with it right then and calls their phone a friend attorney, who we have people in most regions that are known as like the Fifth Amendment counsel. It could be any qualified counsel, but there are folks who do it a lot. That the courts are very aware of. And so like in Kennebec County, Lisa Whittier gets the first call. And so then they would see if she was available. And if not, they would work down a list of qualified people. At the PDS, we were called once. Sort of that moment where right now we need somebody right now, and we immediately dispatched an attorney at the court's request. I don't think we stopped to read the statute to make sure it was contemplated, but Fifth Amendment counsel is paid for by PDS. There's a quick authorization that happens sometimes it's retroactive. But given the emergency nature, it's also very rare. So it doesn't happen every trial. It doesn't happen every week, but it does happen frequently enough that it would be prudent to make provisions for it.
Janet, did you have something you wish to add?
I was just trying to see if I thought paragraph E covered it, but I think I'm coming around to Representative Sinclair's position that maybe it should just be cleared. And then it should say whether indigent or not is included. So it could be, I know don't need to wordsmith now, but my thoughts are in a paragraph B1, legal representation provided to any other person where it's constitutionally required. And we just need to decide if you want the word indigent in that sentence.
That's a good suggestion. How do we feel about that, committee members? A suggested amendment to paragraph B. Yes, Representative Lee?
I think I definitely want more time to think about it. Because if you don't put indigent in that sentence, that's every criminal case potentially.
Yep. Representative Sinclair?
Yeah, my objection to that suggestion was that B only covers civil cases. And that's part of why I thought that E might be a better fit, because it neither restricts to criminal or to civil, nor does it mention the word indigent. So I thought that it might be a good fit there. Again, these services are rarely used, but it's pretty clear in those instances that if you don't adequately provide for someone's Fifth Amendment rights, you're also imperiling another individual's Sixth Amendment rights.
Okay. So maybe where we should head with this potential committee bill is to ask Janet to work with ED Tarpinian and with Representative Sinclair and Lee to come up with the right language. And then we can bring this back for purposes of taking a vote on the language on whether we want to report out a committee bill at that time. Janet, what do you think of that plan? I should have probably asked you to suggest a plan first.
So partly why we are here today is because of the time it takes to print a committee bill, get it referred, get the hearing, get the work session. I believe in that time, I could work with folks to work on that language. So it might be worth saying, I know how to do the 4036 fix. If I caught it correctly, that it's paying until the child protection case is dismissed, we could add that. Either I would go with your suggestion, either put in placeholder language in paragraph E about Fifth Amendment counsel and know that that might need to be changed, or leave it out and know that folks are going to ask to add it during the work session process. Either way, I can bring the language back to you before it's printed so you can check it, but I would hate to slow it down just because I remember last session, the committee bills took so long to print, and maybe it won't take that long now. It's just there's so much to do in the revisor's office. I don't want to put it to the bottom of a pile in a month.
Thank you for looking out for all of our best interests. So let's do this, committee members. There is a disclosure on here that says it's reported out by the committee, but it's not, we're not taking a position on the substance. We also have the opportunity to amend it when it comes back to us, or vote against it, or vote in favor of it. And so given the need to get the process started in the revisor's office, how do committee members feel about taking a vote today on whether to report out this as committee legislation? And it would be the salmon colored document, and then also the fix to 4036, and then potentially the Fifth Amendment language, if we could catch it mid revisor, Janet, or would that have to wait till it came back to us?
We could probably catch it mid. I could work with the three folks you mentioned to work on that language. I'd probably put placeholder language in to remind myself.
Perfect. Thank you. So does any committee member wish to weigh in on whether that is an adequate way to move forward? Representative Henderson?
Thank you. I was posturing to raise my hand, so thank you for recognizing that. When it's appropriate, before we vote, I think we should have caucus.
Okay. Any other comments or committee discussion? Before we caucus, I just want to remind everybody that this vote is whether we're going to consider this, have a public hearing on this legislation. Voting to have this legislation issued as a committee bill does not bind anybody to vote for or against it. Okay, so should we take, I think we're ready for that vote once we have a caucus. Looks like everybody is in agreement with that. Okay, so let's take like a 5-minute caucus, everyone, returning at 4:25.
When she said she was gonna go.
Welcome back, everyone. Thank you for the quick caucuses. So I'm a little torn because we need to vote on whether we're going to report out this legislation, and we are missing Co-Chair Kuhn, who had to run to an appointment. Janet, if we do a vote at this time, would Representative Kuhn have a chance to vote when she comes back into the room?
Certainly, or we could talk about the other bill that involves PDS and the main judicial branch, and you could vote them both later. Up to you.
Okay, Senator Hagan.
I wouldn't mind voting there.
Okay. Okay, so let's vote on this. So this is a committee vote on whether to vote out legislation as presented and discussed today on the salmon sheet, the white sheet, and with the fix regarding the Fifth Amendment defense. And this is for the purposes of getting things moving forward in the revisor's office. Janet?
I have listed you as the person making the motion, but I don't have a second.
Okay, so I have made that motion as seconded by Representative Sinclair.
Thank you.
And so committee members, all those in favor, raise your hand, and then we're just going to hold them up so Janet can record our initials. And that is unanimous of those present.
Thank you. So 8-0, so that should be able to be reported out, and I will inform all the people who need to be informed that you wanted to come back.
Thank you. Okay, and so we have a second piece of PDS.
Okay, so you received two different reports in response to LD 1101. So hopefully you have a packet. Supi was very helpful in making sure that everyone still had a copy in front of them. So I just wanted to publicly thank her for that. That is on top. It should be buff or a close color to buff that shows you actually the text of LD 1101 to remind you what it did. And it created this new statute, Title 4, Section 1807, which is in Section 3 of the enacted law. And that's the law that is set to repeal on February 1st, so very soon. And it authorizes or requires the Commission on Public Defense Services to pay attorneys appointed by the District Court, Superior Court, or Supreme Judicial Court to represent folks eligible for indigent legal services, but for whom there isn't a public defender, an attorney on the roster, or employed counsel. Those are counsel like public defenders, but that work in child protection cases. So if one of those folks isn't available, if the attorney is qualified by having at least 3 years of relevant legal experience, or for the Supreme Judicial Court cases, they served as a law clerk analyzing similar types of cases, and they're willing to undertake the representation, the court can make the appointment, and this statute provides that the commission will pay for those court-appointed attorneys. Again, that repeals February 1st, 2026. So sections 4 and 5 of the bill required, or of the enacted law, required the judicial branch and PDS to report back on several topics, including what to do with this statute. And so you received these reports last week. And if you look on the back of the judicial branch report, the last paragraph, they do recommend that the statute not be repealed until February 2028. So that would be a 2-year extension of the statute. By contrast, if you look on the last page of PDS's report, they do think that the statute should be repealed. as it is currently written, so February 1st of 2026. If you agree with that recommendation, you do nothing and the statute will repeal. That's already built into the statute. They also had a separate recommendation, however, which is to prohibit direct court appointment of any attorney without consent of that attorney, is what I've written down. I think they also wanted to ensure that the attorney was qualified or eligible under PDS rules to provide that representation, which I did not realize. So with my mock-up draft legislation, I didn't include that, but that can certainly be added. So if you look at what I presented to you as options on the purple handout in response to these two reports, option 1 would be to enact emergency legislation where the repeal date automatically is February 1st, so very soon. It would be emergency legislation to amend that statute and provide that it's February 1st, 2028. That probably actually won't work. I'll talk to the reviser because February 1st will have already happened. The statute will have been repealed, so we'll probably have to reenact it. But all of that can be worked out with the revisor's office if you agree with this in concept. So that could be proposed as legislation. You could say, we're sure we want it to happen, report it out with an official roll call vote, and that would be voted on the floor. Or you could say, we want to have a hearing on it and we'll see, do we really think that this authority and to have PDS pay for these private attorneys appointed by courts should be extended, and you could go through the hearing and work session process. On the back, option 2, this is my mock-up of this legislation. I believe PDS would write it slightly differently, and I can work with them to make sure it's written correctly. And this would be requiring the consent of a private attorney before they are appointed to represent someone. And I think that this could be amended with the input of PDS to clarify not only must the person consent, but they also have to be deemed eligible to take the case by PDS. And then the judicial branch actually thought, instead of saying that the court can't appoint these folks, that you would instead say that PDS wouldn't be responsible for paying these folks unless these criteria would be met. So less about whether the court has authority to appoint an attorney and more about when is PDS required to pay the attorney. So that's very different indeed. So that's option 2, either as written or with any of those amendments. And option 3, there's actually 4 options, but option 3 would be to put these both in the same bill. Or 4, you could report out separate bills. I guess 5 is nothing. So you have many options, and I did give you the disclaimer language if you wanted to move forward. You weren't certain that you agreed with the proposal, but you wanted more information on it. We could add that disclaimer language at the bottom to either bill, both bills, neither bill, combined bills, separate bills, all options.
Thank you. And thanks, Janet. Is there there is the same timeliness issue that we confronted with the
This one
previous?
actually has more of a timeliness issue. If you want to do something about this, this statute will be repealed February 1st.
Right, but I mean, there is an incentive for us to get it to the reviser as soon as possible, I guess was my question to you.
Yes, because even if you want to prevent the statute from being repealed, it will be repealed. I don't think there's a situation where that can happen by February 1st, where it can get through all the votes.
Right.
So,
because that's 10 days away.
yes. So the amount of lag time before it were to be amended is what we're talking about here. So knowing that there will be lag time, I guess it's not emergency, but depends on how you feel about it. That's a policy question, really.
Okay, so what I'd like to do first is take committee questions for Janet, and then if we could hear from both Julie Finn on behalf of the judicial branch and Freyla Tarpinian on behalf of PDS, and then we can have committee discussion and decide where we're headed on this. Yes, questions for Janet. Go ahead, Representative.
Thank you, Madam Chair. So quick question, just on option 2. What would be the value of doing this without changing the date? would it have any material value without changing the date to February of 2028?
So option 2 is the version proposed by the Commission on Public Defense Services, although my language, so they might write it differently. But they did not want to extend that statute. So they wanted that statute to go away, which requires them to pay these private attorneys appointed by courts. And instead, they want a statute that says courts can't appoint counsel who aren't willing to take the case. And from further email communication, since this was copied, not only must they be willing to take the case, but they must be deemed eligible to take the case. Now, the judicial branch would have further amended that to talk about when PDS pays, but I think then we go back to the statute that's being repealed. So I don't know that they agree on that point. But the first option is really about, do you want PDS to be required to pay private attorneys who aren't currently on a roster to accept these cases when they're appointed by courts, if they're qualified and willing? And the second question is, do you want as a general rule to say courts can't appoint somebody who's not willing and maybe not qualified, if you add that to the language as well?
Okay. So just for clarification, option 1 would simply indicate who pays for this, which would be PDS, and that's extending that. But option 2 would make slight revisions, but give the courts the ability to appoint counsel.
That's a hard question to answer because the courts would say they already have that ability. It's inherent. But it would be sort of
That's right. That
recognizing a limitation on that authority,
Okay.
which is that if the person's not willing, you can't appoint them. And then perhaps adding, if the person's not qualified, you can't appoint.
Okay. Thank you.
Representative Lee.
Trying to understand how option 1, there's no plausible way that this bill would pass because it'll be repealed by the time.
Yes, I'll rewrite it to reenact the law.
Okay,
I realized.
that answers my question.
I
Thank you.
realized that 10 days is just not going to happen. So I'll just reenact it. Well, you will decide whether you reenact it.
So committee members, are we ready to hear from Julie Finn and Freyla Tarpinian on this?
Yes, or sorry, we thought it would be helpful to have language in front of you, but maybe we've proved that it's not.
But I think it is helpful. It helps us focus. And we may need a couple of minutes. Do you need a few more minutes? I'm just a moment. So committee members, I think I put Julie Finn and Freyla Tarpinian on the spot a few minutes before they were ready. But I think that now they can speak to us about their suggestion for what the legislation would look like. And thank you both for joining us. And if you could just again introduce yourselves and then describe the changes in the purple document.
Sure. Julie Finn, for the Maine Judicial Branch. And I think what we discussed is a little bit of a hybrid of option 1 and option 2, maybe option 1.5. We'll call it. So the part from the option 1 that remains is a sunset date, but instead of February 1, 2028, moving that forward to April 1, 2027. So it's a little bit longer than a year. And then in terms of option 2 on the other side, the section 1802B subsection 2, we would replace what's there with a similar provision, which I can read to you and I can provide to Janet. When a court assigns or appoints a private attorney to represent a party entitled to indigent legal services, the Commission on Public Defense Services is not required to compensate the private attorney unless, 1, the attorney consents to the assignment, and 2, is determined eligible by PDS to receive the assignment. So it's similar to what's there, but it adds the eligibility piece.
Thank you. And Freyla Tarpinian, did you introduce yourself and share any additional comments?
Yeah, this is Freyla Tarpinian. I'm the Executive Director of the Maine Commission on Public Defense Services. I think that is sort of the options that are, it doesn't ameliorate all of the concerns that PDS has. But it does ameliorate some of them. The consent piece is important for our attorneys for their protection. I don't know what it means for attorneys who are appointed who are not eligible. I would make that's an open-ended question, but ultimately I think PDS's responsibility is to pay attorneys. Our mission actually is just to process payments and make sure attorneys have oversight, training, and supervision. I don't know what provisions the court may make for alternative arrangements. And quite frankly, I don't think the PDS has a place to be involved. If the court makes alternative arrangements, we are happy whenever clients are served. We do want to protect attorneys, which is what the consent piece is about. It's important. But if that is a language that's more agreeable to the judicial branch, PDS that's what PDS is really mission is who are we responsible for payment to? Given that I was in front of you asking for a lot of money to pay attorneys recently.
And are you both envisioning that option 1 and option 2 would be as amended or as revised this afternoon would be combined into one piece of legislation? Or would remain as 2 separate pieces of legislation?
I'm not sure why they couldn't be combined.
In my mind, it seemed appropriate to combine them. Okay.
I don't have an opinion about how legislation is through.
So then we would combine them, committee members. At least that would be my suggestion. So I'm going to open it up for questions, and Representative Sinclair, I saw your hand 3/4 of the way up. Go ahead.
Thank you, Madam Chair. This is a question for the judicial branch. Is the judicial branch saying that they will not appoint counsel unless that counsel is willing and is, in the eyes of PDS, capable to take the case? Or is the judicial branch instead saying that if they should appoint someone who is either unwilling or is not deemed eligible for that case, that the branch will absorb the costs of paying for that counsel in that matter without adding a fiscal note, or neither of those things?
I think it's the first one. That they will appoint someone who is willing to take the case and eligible deemed eligible for PDF.
Other questions? Was there Representative Lee, was your hand up?
That's not the language that I just heard, and
Yeah, it's being worded in a kind of an inverse way. And so I'm going to ask if Julie Finn, could you please read the language back again so that committee members can digest it. And again, committee members, the vote we would take this afternoon is a vote. Oh, Janet has the language. Okay, we're gonna get the language so everybody can look at it. But again, our vote this afternoon is to have a committee bill reported back to this committee for a public hearing and a work session. So we'll be at ease for just a moment or two. Thank you, Janet. That's super helpful. So let's take a moment to look at the language. And I have a thought that I want to share with everyone once people have had a chance to read it. So just look up when you're done reading, please. So I think what we're all a little concerned about is that the way this reads, it would say the court doesn't have to pay. And this is something that we ran into last session when we were working on 1101, which is that there is perhaps a dispute between whether or not the court has the inherent value, the inherent authority to appoint counsel. And the approach we took in 1101 was that we weren't going to engage in trying to resolve that dispute. And so this language that we're looking at now similarly doesn't engage in that dispute. It simply looks at, it's not saying a court can never assign or appoint a private attorney. It's saying a court is required to get the consent and determine the eligibility of the attorney in order for it to be considered part of the public defense system. And so it sounds to me, and Julie, maybe you can comment on this, how frequently would the court assign or appoint somebody who is not consenting and not eligible? Was that something that we anticipate happening, or is, and I'm just trying to give the committee a sense of whether this is a real dispute or that, there are going to be some that are covered and some that are not, or if it's simply a matter of maintaining the judiciary maintaining its position that it has that inherent authority. And so if you could comment on that, please.
Thank you. I think you described it correctly in terms of the inherent authority. And I mean, it's speculating to some degree, but I can't imagine they would ever appoint someone who doesn't consent, who isn't willing to accept the appointment. I can't imagine that ever happening. In terms of the eligibility, that's harder to speak to because I'm not entirely sure how that works. I think the law would requires that a judge consider them to be qualified to take the appointment. Whether that is eligible under PDS standards, I'm not sure. But in those, if the person were not under this language, PDS would not have to pay them.
Fred Tarpinian, did
Is
you
that
wish to comment on that at all?
Without wading too far into, I think, a debate that's not going to be solved today. I think there have been some court orders issued that have been appointed attorneys, cases that they have not consented to. So far, they have been PDS attorneys, and I think 1709 cited that when 1709 goes into effect, that will clarify that that's not permissible.
1796.
1796. I'm like
yes.
saying in my head now, like it's not right. 1796. Thank you, Chief.
Sure.
Thank you, Julia. That will clarify that. The orders that were written were very broadly described and certainly indicated that an attorney could be drafted into service without compensation. That we heard a lot of feedback that was pretty apprehensive. Now, this is not a widespread practice. I don't anticipate it happening. I'm sorry, I don't anticipate it happening a lot. It was very unusual. We were very surprised by the order. But the conversation that came back to PDS was just sort of, so you're protecting PDS attorneys, or are you going to protect the rest of us? I don't believe PDS's function, I just want to say really clearly, is to match qualified attorneys with cases that need staff, and then to pay those attorneys. That is our mission. That is what we are designed to do. I don't believe we have sort of a mission in terms of prescribing what the law says or doesn't say. That the legislature creates the law, judges determine what the law is. I respect that authority. And I respect the process a great deal. So really staying in the lane of PDS. PDS wants clarity on its mission, who we pay, what we pay for, and we will abide by the wishes of this body as interpreted by the judicial branch. So in terms of this language, it clarifies that we are to pay people who are appointed with consent and who are eligible under our rules, which we believe is proper. I don't know that it answers the question of what happens to other attorneys. I don't know. I would worry about that because, to be totally frank, there are very few attorneys that do this work that are not PDS attorneys. And I am very invested in making sure our attorneys are supported and are able to practice as best they can, so that if they can maintain good practices, we will be able to fulfill our mission, which is making sure everybody who's entitled to counsel has counsel. So we have a vested interest in the health and well-being of our attorneys, and I take that very seriously. But where PDS's role is in drafting this legislation is, who do we have to pay for? And so I think that this language does that.
And is consistent with your mission?
Yes.
Okay, thank you. Janet?
I just want everybody to be clear about the difference between LD 1101 and this language, because I just went through that in my head. So LD 1101, which if you go with this new proposal would be extended till April 1st, 2027, states that the commission is required to pay for these private attorneys who are appointed by the courts if those attorneys are willing, if no otherwise PDS eligible attorneys available, and if they have at least 3 years of relevant experience, or for the appeals were a law clerk. So that's PDS has to pay in those situations, but the requirements are not the regular qualification requirements to be eligible to be on the roster. So this proposal, which could be combined in the bill, would say for all time, PDS is not required to pay unless that person is both willing and eligible under the rules. They didn't necessarily go through the rules and get on a roster, but they have to at least meet those qualifications. For that reason, because it's slightly different, if you do want to report this out, I think you need to make the effective date of the second provision, the April 1st, 2027, because it's a different qualification requirement for when the attorney can be, not when they can be appointed, I'm not getting into that, but when PDS would be paying them. Does that make sense? So I think they're slightly different, because I at first was asking myself, does putting these together in the same bill even make sense? But I have convinced myself that there could be a world in which it makes sense, because they are saying slightly different things, but only if this has a delayed effective date to when the other provision is repealed. Does that make sense? I hope I didn't add confusion.
Yeah. So what you're saying is we put them together, we're creating a situation where for court assignments up until April 1, 2027, the original language of LD 1101, which has become law, would remain in effect.
Yes.
That would be reenacted.
Correct.
Okay. And that after April 1, 2027, all those special exceptions to when the court can appoint evaporate, and this process of just needing consent and eligibility applies
That's how I would
after
read it.
April 1. Okay,
if
I'm not
that's
sure
what they meant.
everybody's reading it that way.
Because otherwise I don't know how the two pieces go together.
Okay.
I can sit back there.
Yeah, thank you. Freyla Tarpinian, did you wish to weigh in on that? And then Representative Sinclair, I'll recognize you.
Yeah, we could never support legislation that would allow our rules and eligibility requirements to be completely disregarded. That would be entirely inconsistent with the mission. Our goal and sort of going back to where this came out of our LD 1101 report was simply to make sure that attorneys who are being appointed are consent to that appointment. And we're happy to work on any language that embodies that. We would not be in favor of language that would allow any attorney to be appointed and paid by PDS and completely avoid all of our oversight, both. And I want to point out that the issues that were raised in 1101 that I have not gone back through today because I don't want to take up too much time, but there is a concern that attorneys that are appointed we have no oversight. So behavior or conduct that they undertake that would be inconsistent with the rules that we would require that our attorneys follow could be entirely disregarded, and there's nothing we can do about that. Right now, if an attorney has conduct that's inappropriate, we suspend them. We investigate them. We intervene at a lower level because we don't want to lose any attorneys right now. But if push comes to shove, if their conduct endangers the well-being of their representation of clients, we would suspend them. We lose that ability, and we would not agree to that in perpetuity. That's a really important piece of oversight. The second piece is auditing, and this is maybe more important. So I know, and I'm learning rapidly on my 90th day in this position about the financial history of MCILS and the concerns that have been raised by this committee and by this legislature very reasonably by OPEGA. I'm very aware of those hearings. Losing the ability to have financial oversight and audit our bills would be extremely detrimental to our ability to make sure that we are in good financial stewardship of our work. So we have rules about what we permit, what are permissible expenses and what are impermissible expenses. We have a geographic limitation, we can waive it, but we try to get people to not drive because we don't want to pay people to drive to beautiful Aroostook County from York, because that's not a good use of taxpayer money. We should be using that money for attorney services, not for driving. And so if we are not allowed to, use or rely on our financial rules and constrain the bills, we lose all ability of financial oversight with attorney billing, which has been a concern in the past and remains a concern. It's important that we are able to account for all of our dollars, that those dollars are spent efficiently and effectively, and having no ability to say that's not an allowable expense deprives us of any meaningful opportunity to do that. And so what we do, I think we can work on language. We care a lot about making sure it's consensual appointments within the court's authority. We do not agree to any language that would completely allow attorneys to avoid our oversight and regulation. We are also in the Robbins litigation, the part of the lawsuit that we don't talk about because it's sort of on hold for the one that's the bigger piece is a training and oversight part. And so we are going to go to court and be on trial for our oversight practices. And having an alternative system that allows attorneys to avoid that oversight would undermine our ability to successfully prove to a court that we do an adequate job with it.
So are you envisioning that the option 2 language would be subject to a sunset at the same time as the option 1 language? How are you envisioning that they would fit together?
Yeah, this language is newer, and so I had drafted the different language, which was simply on the issue of consent, which is really the place where the LDL and 101 recommendations came from. I would have to go back and sort of think about this, but if again, the PDS cannot support a long-term system that would allow avoidance of all of our financial and supervision rules. That would not be something that we could support. Although we would like, we're happy to work on the language around consent. We would not be supportive of this coming into effect and then being the rule going forward forever.
I'm going to recognize Janet. And then I know that both Representative Sinclair and Representative Lee have had their hands up.
I feel terrible, like I opened a can of worms. Hopefully I can close it again. So my main point was that there's a LD 1101 rubric and then there's this rubric, and I don't think they can overlap. I probably misinterpreted what the April 1st, 2027 moving forward rubric is. So it says in this starred language that the attorney consents and is determined eligible by the commission. I did not read that as meaning they actually are assigned counsel on the roster or someone else. If that's what is meant by that, which it sounds like it is, I apologize for not understanding that. Maybe that suggests that we can ask for suggestions during the work session if we want to clear up that language, or maybe it was clear to everyone except me. But I really was focusing on that this provision doesn't work with LD 1101 if you reenact it for a certain amount of time. So it could be that LD 1101 reenacted would go through April 1st, 2027. And then this rule, which is consent, and the commission actually has you on their list and they vetted you, is from April 1st, 2027 forward. And I apologize for misreading.
Haven't, who would like to be recognized? Representative Sinclair?
Janet, you may be responsible for having opened the can, but you're certainly not responsible for the worms therein. I had raised my hand out of concern about, my inclination is to simply do nothing and let 1807 be repealed. My concern that I was raising my hand about most recently was because of the audit concerns that Director Tarpinian brought up when presenting the annual report. And it's not clear to me that those are adequately addressed in the currently proposed 1.5, but I look forward to reading whatever language for version 1.5 might come forward.
I'm sorry, I'm missing a page in my handout. And so I was paying attention to that. Can you restate what you just said?
Yeah, in quick, I can't support anything that doesn't address the audit concerns that Director Tarpinian brought up either early this week or late last week, whichever it was. And right now leaning toward letting 1807 be repealed. But I look forward to reading whatever they come forward with as a final 1.5.
Okay. I have a suggestion, committee members, Representative Lee.
Yeah, no, I'm having a negative reaction to option 1.5 personally. And it may just be that I'm not seeing how the two things fit together. And so from my perspective, I also heard Freyla's not testimony, but it almost sounded to me like that was testimony of an ONTP as to option 1 and an OTP as to option 2. And that may be a consequence that could happen. So from my perspective, we should move forward with options 1 and 2 as separate bills. And maybe if they can be combined, maybe that happens, but I'm not seeing it right now.
Is that a motion?
I don't know if I'm ready for a motion,
Okay.
but
I think that I was going to suggest that we move forward with option 1. And if we have an agreement on the consent issue and eligibility, that we add that in, as we work the bill. But I think it's a better idea to have two bills because then the language is published and we have a public hearing on each bill. And then we could combine them or not if, depending on the outcome of the public hearing. So that would be my suggestion. Gives the most public notice.
Right, then I'll make the motion.
Would you like to articulate your motion, please?
I move that we report both options 1 and 2 as 2 separate committee bills and set them both for separate public hearings.
Do you want them as originally drafted or change it to April 1st, 2007 and change the language which I wrote, which was just about consent?
I would defer to Julie on whether she wants to move forward with the original language since that was her suggestion, or if she wants to do the April.
I guess I would say I'd rather keep the original language. We can always move the date back. And we're willing to do that, but
I'm amenable to that. That is amenable to me.
Okay, and then for the second bill, I drafted it just as consent. And I believe that PDS wants it also to say that they're eligible under the commission rules. So can I add that since this is their proposed bill or no?
I'd defer to them on that one as well.
She says yes.
Okay, so the motion is to report out two pieces of legislation. The one is option 1 as it appears on the lavender sheet. And the second is option 2 as it appears on the lavender sheet, but with the inclusion of attorney eligibility. Is that right, Representative Lee? Is there a second on that motion? Seconded by Representative Poirier. Are there any discussion, committee members? I have a very tiny piece of discussion, which is that we are working really hard on this issue and it's really kind of abstract and complex, and seeing how things fit together over the passage of time is challenging. And I think we've chosen a process that will allow us to move both of these forward and do our usual careful job on them in the future, in the not too distant future. So I would encourage everybody to vote for this motion. Representative Henderson?
Yes, thank you, Madam Chair. And I'm also struggling with the intersectionality of these two pieces and got some questions around the timeline piece, but I also think that they're both really important keys to help move us forward. And I think both worth vetting and really fleshing out where we stand on the issue. So I'm happy to support turning these into legislation.
Thank you. Any other discussion, committee members?
Did we have a second? Sorry.
Representative Poirier was the second. Thank you, Representative. Is the committee ready for a show of hands vote on this motion? It appears that we are. All those in favor, please raise your hands. Thank you, everyone. We have one more item to take up this afternoon. This is a review of the LD 547, I think, maybe. 549. I was two off. Which is a letter that we are proposing to send to the Appropriations Committee. In the event that this legislation comes off the table, we want to suggest a fix to one problem with it.
I did forget, and I feel very badly because she reminded me several times that you asked several questions of PDS during the annual report presentation, and they put together very detailed answers to all of your questions. So I'll have that handed out as well, and maybe it can be clipped to your report.
Thank you. And thank you, Director Tarpinian, for answering all of our questions.
Just 1 second for me to organize my papers. If that could be, that would be great. Okay, so for LD 549. Sorry, I didn't hear what you said, Senator Carney, but you had discussed last week potentially asking the AFA committee to modify the version of the bill that is on the special appropriations table. And so taking what was discussed then by folks on the committee, by the Maine Prosecutors Association and by advocates, like you may remember there was a safe nurse here last time. And their description of why removing the ability of someone who has a kit completed after the date in the bill, which would be moved to January 1st, 2028. So if their kit is completed after that date and they've reported their alleged assault to law enforcement, either when the kit is taken or later on, that would be subject to mandatory testing. The version of the bill on the AFA table now says unless the victim specifically requests that the kit not be analyzed. And the proposal was to take that out at the request of the stakeholders. So they gave many different reasons why they believe that's victim-centered and trauma-informed. And so I tried to summarize those in this letter. I wrote draft on the letter because you decided, or at least thought out loud, that you might not want to send this letter unless it was a unanimous decision of the committee. So I put unanimous, but you haven't voted yet. So that's why I put draft on the letter, because we don't know if that's true or not. So this is what that letter could look like. Obviously, I would change it however you direct me to change it. But just to remind you, maybe take a quick glance. I did attach what the proposed amendment would be. And if you want to know how to propose to amend this bill without taking out the opt-out, all you do is not strike that language. So I didn't feel like it made sense to copy that again. So you see this, the proposed amendment and the memo.
Thank you, Janet. Committee members, are there questions on the letter or on the draft amendment for Janet? Yes, Senator Carney?
I'm just would like a little time to read
Yes.
through it, which I'm going to do right now.
Representative Henderson.
Thank you, Madam Chair. Thank you, Janet. This is really well written. I think fairly comprehensive. I guess question I would have for the committee is we obviously wanted to outline why the approach that we are trying to take is both victim-centered and trauma-informed, and outline all the reasons why, which Janet has done wonderfully in this 4 bullet points. Did we also want to mention the adverse effects that could potentially come of keeping in the victim being able to withdraw consent? I.e. the impacts on, anybody or a victim involved in the case being able to tell a prosecution or the investigative body what they can and can't do with evidence in their possession. I think that was the big thing that I took away from the Prosecutors Association, the prosecutors, was that it could be really problematic to create a law where someone could direct law enforcement or the prosecutors on how to handle evidence and what they could and couldn't use the evidence for outside of evidentiary rules that the courts have. So, I mean, well, I think I said all of what I needed to say, but did we also want to highlight that having that language in there could actually be detrimental, that it's not needed to be victim-centered?
We can discuss that, certainly. There was also the question of whether evidence could be in process and how that would be handled. Senator Carney?
I appreciate your suggestion, Representative Henderson. I'm a little concerned that we're making a recommendation to them, and I'm a little worried that the more we introduce additional concepts, like the harder it's going to be for them to they may have more questions the more we add, but I guess I not concerned. I guess I think I'm tired, first of all. I'm fine either way with your suggestion. I would like to include in the 4th bullet point just language that indicates the reason why it's important to not have an option of revoking consent for testing when the victim is a child and the perpetrator is a parent or a caregiver. Maybe something about the presumed influence, though it's that's in the 3rd bullet.
Yeah.
Okay, never mind. No, I mean, actually, I was adding to the 3rd bullet, the explanation, which is that there is, that the caregiver or parent is such a strong, has a strong influence over the victim.
Yeah.
But I'm fine not, if people think it's already in there, I'm fine. It's not
Just stating the impact or.
exact, yeah.
Yep. Representative Lee?
I was wondering, as to Representative Henderson's concern, if the last kind of after the semicolon in the 2nd bullet point, whether that does it for you? Because I was reading that to sort of say the same thing, right? That the status quo allows for the prosecution to still make the decision going forward based on the evidence that they have. In the second bullet point, last sentence after the semicolon, however.
It's clarifying who has control of the test results. Yep. All set, Representative Henderson.
Thank you, Madam Chair. I really just threw that out for the sake of a talking point. It's not a make or break for me. I don't think that this fully encases what I was thinking. I think maybe just that point kind of rung a bell for me, kind of struck for me on one of the reasons why I feel like it's important not to have that in there. It might not have the same impact on everyone on appropriation. So I thought it was worth bringing up.
Thank you. Representative Sinclair?
Thank you. I was one of the three in the minority report that actually passed both chambers. I want to be able to support whatever letter we send if we do send a letter, but I don't agree with the fundamental assertion in the second bullet point. Frankly, I don't think there's anything we can do that will, quote, remove the option for a victim to keep the defendants from exerting undue pressure. I think it's a pretense to claim that this change that we're suggesting here to the language that passed both chambers would somehow make it magically so that defendants can't exert influence. I think it's an utter fallacy.
We do have a representative from Mikasa here, if that's helpful to hear from on that point. Any committee member would care to hear on that? Senator Carney?
I would like to.
Thank you. Could you please join us? Welcome.
So my understanding correctly,
Sorry, could you just start with your name?
Yes, my name is Carly Fisher with the Maine Coalition Against Sexual Assault.
Thank you.
In my understanding, you're saying that you're feeling like there's nothing we can do necessarily to avoid the pressure piece of a defendant exerting pressure. Is that what you're asking about?
Please clarify.
Yes.
I think it's a fair question. I think that I'll say that Mikasa's biggest concern with this is the potential for making promises in statute that we can't keep, right? It's a fair question. I can understand sort of why someone might say that. And I think in the case of minors in particular, if a minor is being pressured to revoke consent, I can see why that would be a meaningful concern. Of these bullet points, that is not my greatest concern either, Representative Sinclair, simply because I do think it is really hard to know sort of when somebody would be pressured and when they wouldn't. However, I do think that there are real serious concerns with implying that there could be a revocation of consent when that's not something that we can promise. For example, if a court order were to overrule that revocation, that could create real issues.
Can you restate that again? I'm sorry, we're all tired
know.
at the end of the day,
I
but
know.
that's an important point. I want to make sure I get it.
Right. So this is this clause, I think, is the one that makes a lot of sense theoretically, right? We always want more options. We're always going to advocate for more options. However, the concern is that we're hearing a lot of folks representing a concern that if we say to someone, you've reported it and now you have this choice to revoke consent, if we give that option and we put it in statute that they can do that, we want to be really sure that that's true, but we're not sure that actually is true, right? And you heard Shira Burns from the Maine Prosecutors Association talking about a few examples of a time when we couldn't actually follow through on that promise. So two of the examples she gave are, one, what if it's already at the lab? What if it's already been opened and testing is halfway through? What do we do? Do we stop? Can we stop? Is that something we can promise? No. The other concern is that if a judge put in a court order and sort of ruled that that kit had to be tested, it wouldn't matter what the victim survivor said. So it's a thing that feels well-intentioned, but can't actually be followed through on. And we're very, very careful not to put things in statute unless we're really sure that we can follow through. Which is why we are in favor of taking this piece out. And we do feel strongly that the rest of this bill is trauma-informed as is.
Thank you for that. There are questions? Senator Carney?
Thank you. So do you think that instead of explaining to the Appropriations Committee that the bill is victim-centered and trauma-informed without that language, that it's better to just explain the practical concerns about it?
The practical concerns meaning that we can't promise that we can follow through on it.
Yeah.
You all know them better than I do. I am generally of the opinion that giving really sort of simple and clear language and not leaving too much to be confusing is helpful, especially with this volume of documents that they're reading all day, every day. I think keeping it high level and basic could be helpful. That's just my 2 cents though.
Yeah. Other committee members' thoughts on, I don't know which way we should go on this, but I'm just trying to throw out ideas that might help us move to a resolution. Yeah, Representative Lee. Oops, I'm sorry, I'm not chair.
Just gonna let you roll with it.
I think you made a good decision calling on me. I I think my question is more one for Representative Sinclair, and is it opposition to the inclusion of bullet point 2 generally, or is it the agree? I mean, you can't remove the option. So is it to that language, or is it to the whole principle of 2?
Okay, go for it.
Yes, please, go ahead.
Thank you. I actually really liked the articulation that Ms. Fisher offered in terms of the fact that the choice that we had passed for victims was actually a false promise and therefore ought be stricken. I agree with that suggestion. I disagree that making this change will magically prevent defendants from exerting undue pressure. I think that's an utter fallacy and is in itself a false promise.
So, let me just offer another way to handle it would be to strike that and change the rationale to the practical considerations that we just heard. Representative Henderson, you had your hand up, and then Representative Sato.
I was just going to offer, rather than drawing the hard line to saying that it prevents defendants from exerting, just that maybe it mitigates the effectiveness when defendants, if defendants may try, right? That we're trying to, we know that some defendants are just simply going to try to coerce people into doing what they want. But if we can find ways to mitigate that effectiveness. But now I also think we're getting at a time where we're talking about semicolons and wordsmithing things, so.
Thank you. Representative Sato and then Representative Poirier.
Thank you, Madam Chair. I mean, I think as someone who was one of the 3 who voted for the minority amendment at the time, I actually concur very much with Representative Sinclair. I think that the talk about false promise is thank you, Ms. Fisher, because that is the clearest explanation that we've had at all on this bill about the opt-out. And so I think that will really help AFA prove clarity, and that's actually moved my position on opt-out, because even to this point, I was still on the fence. I just really wanted to make sure that this legislation is getting over the finish line and getting funded. But now I really see what you're saying. And so I would be in favor of honestly just like striking all the bullet points and just replacing it with that explanation. Food for thought.
Representative Poirier.
Thank you, Madam Chair. I would be in favor of changing that first section, the first line of section 2 there, as Representative Sinclair voiced as well. He made some good points there, and I appreciate that. Helps me wrap my head around all of it too, because this was an intense bill. But I do think that having the other pieces, the bullet point 1, 3, and 4 would be helpful to people on appropriations as well. So perhaps just striking that first sentence and adding in the information that was just provided to us from the victim's perspective would be a good idea. I would be in favor of that.
So maybe lead with the 2 practical examples regarding implementation, and then go on to these points as further reasons for the change. Does that kind of get us there, Representative Henderson?
And I think that kind of wraps up my first point, which is to reaffirm to the committee that this is still victim-centered and that whole thing, but also like the practical reasons behind why we decided to have this conversation again.
Would the committee feel, and we'll do a straw vote, I suppose, before we move on, but I'm wondering, is the committee comfortable having Janet work on a revision and then have it come back to us again before we move forward? Okay, I don't think we need to vote on that. No, we're just directing.
So I understood,
Mhm.
except for what to do with the second bullet point here. I actually struggled with writing this for precisely the reason you said. I was just trying to write down all the reasons I heard. So I actually rewrote this sentence in a way that's clearly not coming across, that they wouldn't be able to do the pressure to revoke the consent because revoking consent wouldn't be available. But if that's not coming across clearly, I'm just looking for guidance. Do you just want me to strike that whole bullet point?
Representative Poirier?
My understanding was striking the first sentence of the second bullet point and replacing that with what information she's given to us. But I think that, you know, the second sentence, I think, is something that's helpful for people to hear.
So you're suggesting removing the first sentence in
Correct.
bullet 2.
Correct. And replace that with the practical information we've received.
Committee members? Representative Lee?
That makes sense to me because it sort of, it would state that we're getting rid of this because we think it's a false promise. And then the second sentence sort of explains why it would be a false promise. Because the prosecution still controls the case.
All right, I'm seeing a lot of nodding heads. Any concerns with moving forward in that manner? Okay. Janet, do you have what you need?
I'm just going to ask that I can run the language by Carly. And then also, since she's sat here twice, maybe pick a date with her.
All right, thank you for staying with us all afternoon. That was extremely helpful. All right, committee members, anything else for us, Janet? Or Suki?
Have a lovely evening.
Okay, motion to adjourn. Do we have a second? Thank you, all in favor? All right, thank you, everyone.